Hey, Peter, this is Dave Alcarengi doing a sound check. Can you hear me?
I can, Dave.
Very good. Thank you.
Hi, this is Robert Kane. Can everyone hear me?
We can.
Great.
Good morning, everyone.
Morning, Your Honor.
Morning. Well, good.
Your Honor. Morning.
At least somebody could hear me. Doug, are you on the call?
Yes, I am. I'm
okay.
Ready. Anytime you're ready, I'm ready to start.
We can go on the record.
You're on the record.
All right. Good morning, everyone. We're here for day 2 of the Washington Gas Light Company's rate case hearings in Public Service Commission case number 9651. Are there any preliminary matters that we need to take care of before WGL calls their next witness? Sounds like it's to you, Mr. Dodge.
Good morning, Your Honor, and thank you. At this time, I will turn the microphone over to my colleague, Mr. Kane, who will be sponsoring and defending our first witness.
Good morning, Mr. Kane. It's good to see you.
Good morning, Your Honor. It's good to see you as well.
Go ahead and call your first witness.
Okay. Washington Gas would like to call Aaron Gibson to the stand. Mr. Gibson is ready to be sworn in.
Okay, thank you. Mr. Gibson, will you raise your right hand? Do you swear or affirm that the testimony you're about to give will be the truth?
I do.
Thank you. Will you spell your full name for the court reporter and then go ahead, Mr. Kane?
It is Aaron, Aaron, Gibson, Gibson.
Okay. Okay, Mr. Gibson, who are you employed by?
I'm employed by Washington Gas Light Company.
Can you give us your business address?
6801 Industrial Road, Springfield, Virginia.
And what is your current position at Washington Gas?
I am the Director of Regulatory and Utility Revenue Accounting.
How long have you been in that position at Washington Gas?
I've been director of the 2 groups for about 2 years now. I was formerly the manager of regulatory accounting, and I've been doing that for around 10 years total.
Okay. I'd like to draw your attention to your direct and rebuttal testimony. Mr. Gibson, are you the Aaron Gibson who filed direct testimony on August 28th, 2020, which consisted of 34 pages of question and answers, as well as exhibit ABG1 through ABG7?
That's correct.
Mr. Gibson, did you also file a public and confidential rebuttal testimony, which was filed on December 8th, 2020 in this proceeding, which consisted of 53 pages of questions and answers, as well as exhibits ABGR-1 through ABG-7? R6?
I think there were 54 pages, but yes.
Okay. Your Honor, I would like the Mr. Gibson's direct testimony to be marked for identification purposes as WGL 15. I'd also like his public rebuttal to be marked as WGL 16 and his confidential rebuttal to be marked for identification purposes as WGL 16-C.
WGL 15, 16, and 16C are marked.
Thank you, Your Honor. Mr. Gibson, was your direct testimony and public and confidential rebuttal testimony prepared by you or under your direct supervision?
Yes, it was.
Do you have any corrections or changes or updates to make to any of your testimony?
A small correction to my direct testimony, Exhibit ABG3. Ms. Francis pointed out the other day that on the allocation schedules of ABG3, which is the jurisdictional study, they are incorrectly labeled ABG1. And that is the 5 pages of the allocation schedules and the 3 pages of the FERC allocation schedule. They should be labeled ABG3.
Okay. Are there any other corrections that you'd like to share?
To my rebuttal testimony, yes, and I would first like to sincerely apologize to staff witness Afton Hauer. I have never had the pleasure of meeting her in person, and I misgendered her in my rebuttal testimony. All of the references where I use he or him should be replaced with she or her. And other than that, I only have 2 minor corrections. On page 1 of my rebuttal at line 16, the word supplemental direct should be struck and replaced with rebuttal. And then on page 4, line 1, the word supplemental should be struck.
Okay. Do you have any other changes?
I do not.
Okay. If I were to ask you these questions, if I were to ask you the questions, would you provide the same testimony or the same answers that you've provided in your direct and rebuttal testimony today?
I would.
Do you adopt your direct, public, and confidential rebuttal testimony with the changes you noted as your own testimony today?
I do.
Your Honor, Washington Gas would move that WGL 15, 16, and 16C are moved into evidence.
Any objections?
No objections, Your
Thank you.
Your Honor, we do have some rejoinder questions for Mr. Gibson.
Okay, hang on just one moment. WGL exhibits 15, 16, and 16C are admitted, and go ahead with your rejoinder. Thank you.
Thank you. Mr. Gibson, did you review the direct rebuttal and surrebuttal testimony filed by the Office of People's Counsel witness Sebastian Coppola?
I did.
Did you also review the testimony, rebuttal and surrebuttal testimony of staff witness Afton Hauer and staff witness David Valcarengi?
I did.
And did you also have the opportunity to review the rebuttal and surrebuttal testimony of AOBA witness Bruce Oliver?
I did.
Okay. Mr. Gibson, I direct your attention to OPC witness Coppola's surrebuttal testimony on page 64 through 65, where he criticizes your attempt to validate the lowering of the expected return rate 2020 for the pension and OPEB plans. He claims that the company has had ample discretion to either keep the expected return rate at the same level of the prior year's assumption, lowering it, or increasing it based on all available evidence. Can you please respond to that?
I can. So first, pointing out that the company has discretion in and of itself is not particularly meaningful. It ignores the fact that GAAP requires us to adopt a reasonable process in setting assumptions, and that the assumptions themselves have to be rational and reasonable. And that GAAP requirement is no different than when you think about each and every one of us. We all have discretion in the choices that we make, but they are bounded by rationality and reasonableness. Equally, we cannot change our methodology year to year. That would not be acceptable either under GAAP requirements or for our external auditors. And just to reiterate that the company's process, we use a weighted average expected rate of return based on investment analyses from 3 reputable firms, JP Morgan, BlackRock, and Willis Towers Watson. The weighting that we use in that weighted average is based on the assets in our plan. Equally, Mr. Coppola, again in his SIR rebuttal, makes the mistake of referring to an average. He's referring to my rebuttal exhibit, which is a Willis Towers Watson survey. That average is not a relevant comparator because that is looking at all of the survey respondents. And you have to look at the individual assets in the plan. And our plan is higher weighted towards debt and cash investments. And you would expect those are less risky investments that we would adopt a lower return, which is what we have done.
Okay. Mr. Gibson, I direct your attention to page 70 through 71 of OPC witness Coppola's SIR rebuttal testimony. There, he defends his position that the commission should only allow the company to recover 35% of STI compensation and tries to defend his rationale by stating, quote, only 5 of the 14 goals with 40 points out of 90 or 36 achievement rate can be considered as directly benefiting customers, and thus that percentage should be the only percentage allowed for recovery for short-term incentives. Do you have any response to that?
Yes, I just want to point out that he still contains the same math error. 40 divided by 90 is 44%, not 36%. He states in his rebuttal testimony that he relies on the company's weightings of the goals. Those are contained in JOB1. But again, 40 divided by 90 is not 36%.
Okay. On page, I direct your attention to page 68 through 69 of Mr. Coppola's SIR rebuttal testimony. On page 68 through 69, he tries to make the point that the company should remove from rate base in the next rate case the portion of incentive compensation capitalized, which was previously disallowed by the commission. Mr. Coppola then on page 69, starting on lines 13, states that, quote, in past rate cases, the company has not informed the commission that it capitalized a portion of incentive compensation, including the portion that had been disallowed. My proposal would remedy that oversight. Do you have any response to that?
Yes, that is a clear misrepresentation of the facts. The company has always been transparent that labor is capitalized and that incentive compensation as a part of labor has been capitalized. That was true in 9267. And if you go back to the record from 9267 and look at Robert Turanimi's direct testimony in that case, on page 41, lines 4 through 10, he specifically discloses this to the commission. And 9267, to my knowledge, is the first case where the commission ruled this disallowance that we are again applying in this case in my adjustment 13.
Okay. Mr. Gibson, I direct your attention to page 4 of staff witness Val Karenji's testimony. There he states that the inclusion of the short-term compensation and the base upon which wages are derived inappropriately adjust pro forma wages for an additional wage component that is neither known or measurable. He goes on to say that the precise level of short-term compensation to be paid to employees in 2021 is not yet known, and therefore interjecting an unknown element into the development of wages is uncertain because it cannot be known when the incentive payout will be in 2021. Do you have any response to that?
Yeah, first, I would just like to note that the distance between staff and the company has closed considerably as a result of Mr. Valcarengi's rebuttal testimony, and I appreciate that. The only remaining issue between staff and I is whether to apply pay increases to incentive compensation, specifically the portion of short-term incentives that are included in rates. The point I have there is that, in fact, these amounts are known and measurable because we are relying on the test year amounts, as we are with all expenses, as a projection of what future costs will be when rates go into effect. And we are relying on the employee complement that is in the labor adjustment, and incentive compensation is a portion of their pay. It is a component. And so when pay increases occur, they apply to the full amount of compensation, which includes incentive comp.
Okay. On page 7, lines 10 through 17 of staff witness Hours' rebuttal testimony, she states that even though you stated WGL system is designed to serve the coincidental peak, and you stated that, quote, equally, the system is designed to serve a coincidental peak as evidenced by the company's system planning manual, staff witness Hour claimed that you provided no specific example or evidence to support your claim. Do you have any comment to that testimony?
Yes. The company did specifically provide evidence demonstrating that the coincident peak is the cost causative factor for mains. That is demonstrated in the system planning manual that I attached to my rebuttal testimony. It is also demonstrated in the company's normal weather study, which staff adopts. And it is demonstrated in a simplified example that I provided in my rebuttal testimony. So in fact, the only evidence that there is in this case of the cost causative factor for mains is the coincident peak. There is simply no evidence that a non-coincident peak drives the cost of mains.
Okay, thank you. And lastly, Mr. Gibson, in his rebuttal, AOBA witness Bruce Oliver continues to maintain his position on income taxes. What is your response to that?
I would say that Mr. Oliver has not really addressed my rebuttal testimony, and he would have found the error with his tax adjustment if he had simply prepared a tax proof of his revenue requirement, which he did not. But the company did, and it is contained in Witness Turanimi's rebuttal exhibits, specifically RET R8, where we prepared a tax proof of AOBA's income taxes that demonstrate that his adjustment is erroneous. In addition, he says that I don't explain why the effective tax rate by jurisdiction is different. That is verifiably false. If you look at ABG3, there's a schedule in there for the effective tax rate that demonstrates what reconciles the statutory tax rate to the effective tax rate. I provided a summary of that same exhibit summarized on page 39 of my rebuttal, which Mr. Oliver does not address.
Okay, okay. Your Honor, we have no further live rejoinder questions, and I'd like to turn Mr. Gibson over for cross-examination.
I'm sorry, Mr. Kane, you're holding papers up and I'm not getting through. I'm the court reporter. Could you please speak a little louder and put the papers down? Thank you.
Sure, I'm sorry. The company has no more live rejoinder questions of Mr. Gibson, and would like to release him for would like to turn him over for cross-examination.
Thank you, Mr. Kane. Before I turn it over to Ms. Francis, Mr. Cleaver has a question.
Yes, Your Honor, I was just
Statement.
wondering, not just a question, Your Honor. I was wondering if I could get clarification from Mr. Kane or the bench or Mr. Gibson, just on a point. The page number that Mr. Gibson cited from the testimony in case 9267, I didn't catch that. There was like a muffled, may I ask Mr. Kane, Your Honor, what the page site was to the testimony in 9267 that he asked Mr. Gibson about?
Okay, I didn't, but I believe Mr. Gibson referred to, I believe it was, and correct me if I'm wrong, Mr. Gibson, page 41.
That's correct. Lines 4 through 10.
Of Mr. Turanimi's testimony in 9267?
His direct testimony, yes.
Mr. Turanimi's direct testimony, 9267, page 41, lines 4 to 10?
That's correct.
Thank you. Thank you, Your Honor.
You're welcome. Ms. Francis, do you have any cross?
Yes, I do. Thank you, Your Honor.
Thank you.
Good morning, Mr. Gibson.
Good morning.
Mr. Kane, would you turn your microphone off, please?
Mr. Gibson, please, excuse me, turn to page 37 of your rebuttal testimony.
Give me a moment.
Tell me when you're there.
I'm there.
Okay. At lines 15 through 17 on page 37 of your rebuttal testimony, you assert that the commission adopted the company's jurisdictional allocation study in order number 88944. Is that correct?
I do.
Now, I'm going to ask you to please take a look at what has been previously identified as AOBA Exhibit 88944. Your Honor, I believe that's been previously identified as AOBA Exhibit 11.
Yes, order number 88944 is AOBA Exhibit 11.
Thank you, Your Honor. I have reviewed this order, Mr. Gibson. May I assume that you have also?
I have.
All right. Now, I can't find any language in that order in which this commission specifically states that the commission, quote, adopted the company's jurisdictional cost of service study in 9481. Could you please point to where in order number 88944, the commission, quote, adopted the company's jurisdictional allocation service? Jurisdictional cost of service study. Please, I misspoke.
Yes, on page 118 of the order, they discuss it as a part of the cost of service issue in the case. The jurisdictional cost of service allocation study was not controversial in the case. If you look at the appendix for the order in that case, the starting number for test year rate base and the starting number for net operating income comes from my exhibit, which was ABG Supplemental 3, which was the jurisdictional cost of service study. So in order for the commission to calculate the revenue requirement in that case, they necessarily had to adopt the jurisdictional study that I proposed in that case.
Mr. Gibson, please, I think you cited page 118.
I did.
Okay, show me where on that page, please, they specifically adopted the jurisdictional cost of service study. I understand that they used the same number, but where did they specifically say they are adopting your jurisdictional cost of service study? On page 118.
I believe I already answered your question, Ms. Francis. The words you're looking for are not specifically in the text of the order.
Okay, thank you.
Mr. Gibson, I'm sorry, I didn't get your last sentence. Could you lean in closer and speak? Thank you.
Sure. The words that Ms. Francis is looking for are not contained in the text of the order.
Mr. Gibson, am I correct that your rebuttal testimony suggests on page 37, line 15, that your effective tax rate calculations were first introduced in case number 9481 and were not controversial, quote, at that time? Is that correct?
Could you cite the page and line number again?
Page 37, line 15.
That's true.
Now, would you please reference Mr. Bruce Oliver's testimony?
His direct or rebuttal? Or
His
sorry.
direct. And I'm going to ask you first to please look at page 37 of Mr. Oliver's direct testimony. And take a look, please, at table 8. Tell me when you're there.
I'm there.
Am I correct that you have not contested the accuracy of the information presented in table 8 on page 37 of AOBA witness Bruce Oliver's direct testimony?
I haven't, but again, just stating what the effective tax rates are is meaningless. You have to do an effective tax rate reconciliation, which he has not performed. You have to take the statutory rate, and then the only differences should be flow-through income taxes, permanent differences, and then amortization of deferred taxes, something that Mr. Oliver has not done.
Mr. Gibson, I was just focused on the numbers in table 8. You have not contested those, correct?
Objection. I believe Mr. Gibson has answered.
He can answer the question.
I contested what he's using them for, yes.
Mr. Gibson, you're not answering my question. You're answering what he's using them for. I am asking you if the numbers that he's presented are correct in table 8.
In table 8, he references my exhibits correctly.
Okay. Do you accept that in case 9481, the range of the effective tax rates for DC, Maryland, and Virginia was from a low of 19.39% to a high of 22.18%?
Subject to check, I don't dispute that. But again, this analysis is not particularly meaningful.
Now, Mr. Gibson, is the difference between the highest percentage and the lowest percentage in case number 9481, 2.79%?
That's your math, but that is not particularly meaningful.
Did you say that math was correct?
Objection.
Math, I have not recalculated that number.
Would you accept that number subject to check, or we can go through the math?
Your Honor, we would object. It's not relevant to this case.
Your Honor, we believe it is relevant. That's his argument, not mine.
The witness will answer the question. I've heard that he doesn't believe the analysis is relevant, but she's not asking whether the analysis is relevant. She's asking about the numbers and trying to determine which part of, or trying to establish that those numbers are correct. So I'll let him answer the question.
Subject to check, the simple math that you're doing is correct.
Now, if we look at the comparable data in Table 8 of Witness Oliver's direct testimony, this time for case number 9651, would you agree that we find that the effective tax rates by jurisdiction range from a high of 19.99% for Maryland to a low of negative 10.92% for the District of Columbia?
Yes. And the reason for that, again, is that at the time of 9481's filing, the implementation of the Tax Cuts and Job Act's rate reductions were not complete in the District of Columbia or Virginia.
I'm sorry, you're breaking up again. Can you get a little closer? I'm very sorry. It's just the way things are. Could you please a little closer and then speak directly into the computer?
Your Honor, I am just trying to verify his numbers. He is not addressing my questions. I understand he doesn't agree with what AOBA is using them for. All I am are trying to establish not why the numbers are different, but whether the numbers as put forth in Table 8 are accurate. Could you please answer that question, Mr. Gibson?
The numbers you have for 9651, as I stated, are correct.
Would you agree that the difference between the effective tax rates for Maryland and the District of Columbia, in this case, is more than 30 percentage points?
Could you restate your question?
Would you agree that the effective tax rates for Maryland and the District of Columbia, in this case, 9651, is more than 30 percentage points? I'm talking about the difference between 19.99 less than negative 10.92, Mr. Gibson.
Subject to check, the simple math works.
Thank you. Is it any wonder that there is a concern regarding differences in effective tax rates in this case when there is a difference of greater than 30 percentage points, but there was no concern expressed in case 9481 when the difference in effective tax rates was less than 3%?
Could you ask that one more time?
Mr. Gibson, in your testimony, you made the point that the tax rates were not an issue in case 9481. So I'm asking you, is it any wonder that there is a concern now in the effective tax rates when there's a difference in tax rates of 30 percentage points, but in case 9481, there was only a difference of 3 percentage points?
I already explained that in my rebuttal testimony, and if you were listening to my live rejoinder today, it was explained again there.
Mr. Gibson, I listened to your rejoinder. I understand your position, but I know that you have expressed the view in your testimony that AOBA did not raise the issue of the difference in tax rates in 9481, and we are raising it now. So I am asking you, is it any wonder that there was not a concern in 9481 when there was a 3% differential in tax rates, and that there is a concern now when there's a 30% differential in tax rates?
I'm not involved in AOBA's case preparation, so I don't know why AOBA did something in one case versus another.
Well, you stated that AOBA did not raise that issue in case 9481. You stated that. So I am suggesting to you, is that a reasonable explanation of why when there's a difference of 3 percentage points, we don't raise an issue, but when there is a difference of 30 percentage points, a party does?
The methodology for calculating taxes in the jurisdictional study is not changed, so no, I don't understand.
Now I would like you to reference Table 5 on page 35 of the direct testimony of Bruce Oliver. Tell me when you're there.
I'm at Table 5.
Okay. Could you please tell me and the commission why this commission should be comfortable approving a set of jurisdictional allocations that require Washington Gas's Maryland ratepayers to bear the burden of 85% of the company's total test year federal income taxes when Maryland only represents 38.2% of Washington Gas's total plant and service, 43.4% of total annual therm sales, and about 39.4% of average
Ms.
meters.
Francis, I am not picking, please repeat your last couple of sentences, they cut out.
Certainly, I don't want to read my numbers wrong, so I'm going to look up and try to look at my numbers at the same time. I'll start over. Could you please tell the commission, Mr. Gibson, why this commission should approve a set of jurisdictional allocations that require Washington Gas's Maryland ratepayers to bear the burden of 85% of the company's total test year federal income taxes when Maryland only represents 38.2% of Washington Gas's total gas plant in service, 43.4% of total annual therm sales, and 39.4% of average meters for the test year.
Income tax is a derivative calculation. It is based on income, taxable income. There is no allocation of tax in the jurisdictional study. It is directly calculated by jurisdiction. The items that are allocated are permanent tax differences. The flowback of excess deferreds is directly assigned to each jurisdiction based on the orders in each of those jurisdictions. So taxes for Maryland are based on Maryland taxable income.
Why should this commission endorse the company's use of taxable income to compute income tax responsibilities by jurisdiction when that methodology places greater tax burdens on Maryland simply because it provides a higher rate of return and allows the District of Columbia to bear a smaller share of the company's income tax burdens because the district provides Washington Gas a substantially below average rate of return?
Objection. I believe Mr. Gibson has already answered that.
Allow the witness to answer the question.
The reason the commission should adopt it is because that's how income taxes work. They are a rate applied to taxable income. The reason why the District of Columbia has a lower effective tax rate is because we have not filed a case in the District of Columbia for over 5 years. So at the time that this exhibit was prepared in the test year, we have a substantial under-earning in the District of Columbia. So low taxable income offset by very high flowbacks of excess deferred income taxes results in a negative effective tax rate.
This commission has some discretion in the methods it chooses to use to allocate cost responsibilities among rate classes within Maryland. But is it your recommendation that this commission should discretionarily impose greater costs on Maryland ratepayers to benefit underperforming District of Columbia operations?
That's not what's occurring, Ms. Francis. It is a mathematical calculation, not an allocation.
I believe that's all I have, Your Honor. Just let me check my notes. Your Honor, is it necessary that I move AOBA Exhibit 11 into evidence? It's a commission order that we can all cite anyway. It might be cleaner if I do move it in, but it's up to Your Honor.
I think we'll go ahead and accept Exhibit 11 into the administrative record.
Thank you, Your Honor. That's all the questions I have for Mr. Gibson.
Thank you, Ms. Francis. GSA.
Yes, I do have a few questions, Your Honor.
Thank you.
Good morning, Mr. Gibson.
Good morning.
I have a few questions for you about WGL's interruptible load customers. Do you have your direct testimony handy?
I do.
I'm going to refer you to page 30.
I'm sorry. Ms. Singleton, you're going to have to get closer, and I'm sorry, you're just cutting out. I'm sorry.
Is this better?
Let's try it.
Okay, let's give it a try. Mr. Gibson, do you have your direct testimony?
I do.
Can you please turn to page 30?
I'm there.
Lines 19 to 21, you state mains are designed to serve the system peak and do not include interruptible load in the calculation of the required main size. Is that correct?
That's correct.
On the basis of the statement, would it be accurate to say that WGL does not plan or design its system to serve interruptible loads?
In the designing of mains and the load capacity for those mains, no.
So WGL does not build mains capacity to serve the interruptible load.
Right, they're assumed to be interrupted on a design day.
Do you agree that interruptible service provides reliability benefits to WGL's system?
Yes, I do.
Isn't it correct that WGL's interruptible tariff provides that WGL shall have the right to interrupt delivery service of gas whenever, in the sole judgment of the company, such interruption is required to maintain the safe and reliable operation of its system or some portion of its system?
That is my understanding of the tariff, yes.
This means that WGL has the right to interrupt interruptible customers at any time, not just the system peak, correct?
That is my understanding, if the need arises.
Isn't it the case that if an interruptible customer is called to interrupt, but the customer does not comply with that notice, the customer is subject to penalties?
That is my understanding, yes.
Your Honor, I'm going to object to this line of questioning. This is friendly cross, which is, my understanding, is not allowed here.
I'm going to allow it a little bit further, see where Ms. Singleton is going.
I only have a few more questions. I'm just trying to clarify some of the testimony.
Yes, ma'am.
Can you explain what some of those penalties are?
I am not that familiar with the interruptible testimony to the interruptible tariff to describe the specific penalties, only generally knowledgeable that there are penalties.
Okay. Do you know whether firm service customers are subject to similar penalties?
Firm customers are not required to interrupt, so there isn't a penalty for failing to interrupt for firm customers because they are not on interruptible service.
Okay. On the next page of your testimony, page 31, I'm going to direct you to lines 9 through 11, where you state allocating interruptible demand costs would invalidate this tariff class as they would be treated exactly the same as a firm class in the C costs. Is that accurate?
That's correct.
Objection. Again, Your Honor, we're just continuing with friendly cross here.
I just have a couple more questions.
OPC would join into staff's objection and agrees with Mr. Wilson.
Ms. Singleton, are your questions to confirm what Mr. Gibson has written in his testimony, like the last one?
Well, I don't think he directly said the answers that I'm trying to get now. I think they may have been implied, but I'd like to make sure, I'd like to get the record very clear for these questions, and there's only a few more.
Okay, this is the last two questions were definitely friendly cross. So let's hear your next question, Ms. Singleton.
Right. If interruptible customers were to decide to not remain interruptible and switch to firm service, would the reliability benefits of the interruptible load to WGL system be lost?
That I think is beyond the scope of my testimony.
Okay, well, if all interruptible customers switched to firm service, would WGL have to factor in these new loads in determining how much capacity would be necessary to serve all of its firm service customers?
Yes.
Okay, I'm done.
Thank you, Ms. Singleton. Ms. Brennan?
No questions, Your Honor.
OPC.
Yes, thank you, Your Honor. Good morning, Mr. Gibson.
Good morning.
I'm going to start by asking you some questions about something in your rejoinder testimony. Your Honor, I'm going to attempt to share my screen because we're talking about testimony from a case many years ago I don't think it's been marked in evidence, and I want to go through some testimony that Mr. Gibson brought up this morning. Let me take a stab at this here. I've done this before. Here it is. All right, and are people able to see a PDF testimony document on my screen?
Yes, it looks like page 301 of 501.
Yes.
WGL OCR 415-2011, in case number 9267.
That's right, Your Honor. So just for the record, that file name at the top that Your Honor just read, that's an OPC, specific file name. That's how we keep our records. But this is all of the direct testimony, or at least the first volume, I believe, of Washington Gas's direct testimony in case 9267 that Mr. Gibson referenced in his rejoinder testimony this morning. And the specific page that I'm on, if you look at the page number at the bottom, it's page 40 on the PDF that I'm looking at. It's page 301, but the page number is page 40. And this is Mr. Turanimi's direct testimony that Mr. Gibson spoke about. Mr. Gibson, just to set the record straight on this, 9267 was that's a Maryland Public Service Commission case number for a Washington Gas Bates rate case that I believe was filed in 2011. Is that correct?
I think that's correct, yes.
Okay. This morning, in response to some questions from your attorney, you addressed Mr. Coppola's testimony on the issue of the fact that Washington Gas is capitalizing a portion of incentive compensation that has been disallowed as an expense item. Do you recall that testimony?
I do.
Okay. And specifically, you addressed Mr. Coppola's comment in his surrebuttal testimony that Washington Gas has never notified the commission of its practice of capitalizing a portion of incentive compensation that has previously been disallowed. Correct?
Correct.
Okay. And you, in response to your attorney's questions, you accused Mr. Coppola of making a misrepresentation to the commission. Do you recall that?
I do.
Okay. Misrepresentation is a very strong word. Do you agree with that?
I agree.
Okay. All right. Let's take a look at page 40 here of Mr. Turanimi's direct testimony in case number 9267. Now, I'm looking at line 11, and this is page 40, the page before you, the page you referred to. And Mr. Turnimi is asked at line 11, please describe any amounts that have been reflected in adjustment 9 for at-risk pay. Do you see that?
What line number?
Line 11. That should be reflected on the screen, people can see.
Yes, I'm there.
Okay. And Mr. Turnimi explains that the adjustment includes at-risk payments during the test year. He explains this position is not consistent with the Commission's decision in case 9104, but is consistent with the Commission's decision in case number 8959. So I'm going to stop there, and just again for the record, let me just clarify with you. 9104 is an earlier Washington Gas base rate case preceding this one, 9267, correct?
Correct.
In 9104, the Commission disallowed 50% of long-term incentive compensation, correct?
That is my recollection.
So and in this case, though, in his direct testimony, Mr. Turnimi included all at-risk compensation in this adjustment that he's describing here, adjustment 9, correct?
That's correct.
And so when he says it's not consistent with the Commission's decision in 9104, that is the specific point that he's referring to. Is that your understanding?
Oh, that we proposed in 9267 to include all at-risk pay?
Yes.
And that is consistent? Correct.
Yes. Thank you. And then Mr. Turnimi continues on line 15 and going down on page 40 to explain the company's argument as to why at-risk pay should be included, right?
That's correct.
Okay. And then I'm down on line 24 on page 40. And the question that's posed to Mr. Turnimi in his pre-filed direct testimony is, did you make any other modifications to the rate-making treatment of at-risk pay? Do you see that?
I do.
Okay. And when we continue on to page 41, which is the page you were talking about this morning, he says, yes, I did. In a Virginia case, the company's fiscal year 2008 annual information filing, the company accepted a staff recommendation to charge a portion of lump sum at-risk pay to capital accounts. You see that?
I see that.
And he says a portion, right?
A portion, correct.
Yes. And then he says, beginning in fiscal year 2008, the company changed its accounting practice to conform to the recommendation. And since then, the company has included lump sum at-risk pay in the determination of the cost charged to capital on a monthly basis. Did I read that correctly?
That's what it says, yes.
He doesn't say all lump sum at-risk pay, does he?
That's a distinction without meaning. I don't understand what you're trying to point to.
It's a yes or no question. The sentence doesn't say all lump sum at-risk pay, does it?
I believe it's implied, but it does not say that.
You believe it's implied. Thank you. Okay. And then he says, in the development of the rate-making level of labor costs, I included the lump sum at-risk pay in the amount subject to capitalization, right?
Correct.
And again, in this proceeding, Mr. Turnimi and company witness McGee were advocating for the recovery of all at-risk pay, correct?
That's correct.
Okay. And so when he says he included it, this is his proposed adjustment, correct?
It is his proposed adjustment, yes.
Correct. And the commission disagreed with the company on this point of the inclusion of long-term at-risk pay and affirmed the same treatment of the cost as what was decided in the previous case 9104, i.e. 50% inclusion of long-term incentive compensation, correct?
Could you state your question one more time?
On the issue of whether 100% of long-term incentive compensation was recoverable from ratepayers, the commission disagreed with the company and affirmed what it said in the previous case 9104, that only 50% is recoverable, correct?
So I'm a little lost because the page you're referring to refers to at-risk pay. Long-term incentives are a component of at-risk pay. And yes, the commission disallowed 50% of long-term incentive expense as a part of their order in 9267.
Did the commission expressly allow the company to capitalize? Let me ask the question this way. Did the commission in its order in 9267 discuss in any way the issue of capitalizing a portion of long-term incentive compensation?
I don't recall that being a controversial issue, so I don't know that that would get discussed in an order. My understanding is that this commission adopts the FERC Uniform System of Accounts for regulatory accounting purposes, and the gas plant instructions specifically allow the capitalization of labor cost as a component of plant in service.
Did the commission expressly allow the company to capitalize those portions of at-risk pay that it excluded from the revenue requirement in the case?
Objection. Mr. Gibson just answered his question.
He didn't answer. He didn't answer the. Thank you, Your Honor.
Could you repeat your question?
Maybe we should turn to the order. I'm going to flip to another document. Again, Your Honor, this is not marked. I didn't anticipate any of these questions. This is based solely on what I heard this morning. I'm going to flip over to the order. Let's see if this works. I'm now looking at the commission's decision on the issue of long-term incentive compensation, and it begins on page 28 in commission decision, and it continues on to page 30. Mr. Gibson, have you reviewed this order?
Yes. The only thing that was controversial was the amount included in test year operating expense. And so that is, I believe, all that is discussed.
Mr. Kleber, will you identify the order, case, and date, please?
Yeah, good idea, Your Honor. Thank you. I've on my screen right now order number 84475 from case number 9267, dated November 14th, 2011. And this is the commission's final order in the Washington Gas base rate case from 2011, 9267. And I was asking I directed Mr. Gibson, as I have on my screen, to the discussion, the commission decision beginning on page 28 on the issue of long-term incentive compensation. Did the commission, Mr. Gibson, I'll ask the question again, and you can, let me ask this, strike that. Do you have access to this order right now?
I'm viewing it on your screen, yes.
Okay. All right. Well, we can read it on the screen. That's fine if it's okay with the judge. You want to take a look here at this discussion starting under commission decision. Do you see that?
Right. I already, I think, answered your question, which is the only thing that was controversial in that case was the amount included in test year operating expense. I believe that's all that's discussed here. If you're asking me to point to somewhere where they talk about capitalization, I do not believe it is there.
Yeah. Let me go back to Mr. Turanimi's testimony. When he discusses here on page 41, the change in accounting practice. Strike that. Let me ask this question. When Mr. Coppola makes the proposal that he makes in this case, he's not proposing that all of the at-risk pay that the company capitalized be removed from rate base, is he?
Could you ask that one more time?
In this case, Mr. Coppola is not recommending that all of the at-risk pay that the company capitalized be removed from rate base, is he? In other words, let me ask it this way, Mr. Gibson. In this case, Mr. Coppola is only proposing that that portion of incentive compensation that's been disallowed should not be capitalized and included in rate base, correct?
That's correct.
Okay. Okay, so let me ask this question and we can move on. After reviewing this testimony in 9267, where Mr. Turanimi proposed that the company be allowed to recover all of its long-term incentive compensation, where Mr. Turanimi described what he styled a modification, where the company includes lump sum at-risk pay in the determination of the cost charged to capital on a monthly basis, and where the commission issued a decision disagreeing with the company and disallowing 50% of long-term incentive compensation in expense, and did not address the issue of the portion capitalized, do you wish to take back your claim this morning that Mr. Coppola has misrepresented to the commission that the company has never informed the commission that it's still capitalizing a portion of incentive compensation that's been disallowed as an expense item?
I do not. The company has been transparent, and it's a misrepresentation of the facts to say that we have not. We were transparent in case 9322, which I believe you were present in because you crossed me in case 9322. We did it in that case. It was clear in my exhibits in that case. It has been clear in my exhibits in case 9481 and 9605 and this case.
Has the company, Mr. Gibson, has the company ever affirmatively informed the commission that it's still capitalizing a portion of incentive compensation that the commission has determined is inappropriate for ratepayers to pay for? Has the company ever affirmatively informed the commission of that fact?
Objection, Your Honor.
What's the basis of the objection?
Relevance.
Overruled.
I believe the company has in case 9322 in my filed exhibits in that case. That was subsequent to the determination in case 9267.
Has the company ever in testimony expressly told the commission of that fact?
Objection, Your Honor. Asked and answered.
It hasn't been asked and answered. He talked about his exhibits, Your Honor. And the question was an express representation. Thank you.
I believe in my discussion of the labor adjustment, I specifically mentioned that labor is capitalized.
Did you specifically say that that portion of incentive compensation that's been disallowed on the basis that it's related to the company's financial goals and is not appropriate for ratepayer recovery has been capitalized and is therefore contributing to the revenue requirement?
Objection, Your Honor.
Basis?
Your Honor, the form of the question, and this is also getting outside of the scope of direct and rebuttal.
Overruled. Mr. Cleaver, can you ask your question again, please?
Yes, Your Honor. Let me try to remember what I said.
Mr. Gibson, did you understand the question? Or do you need it restated?
I believe he asked if there were some specific words in my testimony from 9322 or any other case. And
Okay, you can answer the question, Mr. Gibson.
those specific words that you mentioned, Mr. Cleaver, do not appear in my testimony.
Thank you. All right, Your Honor, I'm going to stop sharing my screen if that's okay. And then, because now I'm going to go back to what I had planned to ask about. Okay. Thanks, Your Honor. Sorry for the delay. Just wanted to make sure I wasn't sharing because I'm looking at trial notes now. Thank you. I'll be ready to proceed in just a moment. Thanks.
If the parties would indulge me, I think now is a good time to take a 5-minute break. I would make sure everybody remembers their ethical obligations not to discuss the trial with their witnesses during this break. But we're going to take a 5-minute break. We can go off the record.
Thank you, Your Honor.
Looks like we need to wait a couple of minutes for Mr. Gibson to return.
I'm here.
Video isn't on, Mr. Gibson. Oh, there you are.
Yeah.
Okay, we can go back on the record.
We're on the record, Your Honor.
Thank you, Doug. It's your witness, Mr. Cleaver.
Thank you, Your Honor. Mr. Gibson, if I could ask you to turn to your rebuttal testimony and specifically page 12. Are you there?
Give me a moment. I'm on page 12.
Okay. There you're, it's starting at line 1. There's a question and you go on and you're addressing Mr. Coppola's proposed disallowance to compensation expense, and you explain there that, in your opinion, he hasn't offered any new or compelling arguments. Do you see that?
I do.
Okay. And then you say here on line 6, you say, equally, the commission should view this in the context of OPC witness Coppola's testimony in total. OPC witness Coppola has cherry-picked a number of adjustment. I guess that's a typographical error. Is that should be adjustments with an S?
Correct.
All reductions in the cost of service, and the material ones are unrelated to any genuine reduction in cost to achieve a recommended decrease in the company's rates. Thus, the commission should see this for what it is, a results-oriented adjustment. Did I read that correctly?
That's correct.
Okay. Mr. Gibson, you're very familiar with rate case testimony, correct?
I am.
And you've reviewed, is it fair to say you've reviewed dozens of pieces of testimony from witnesses for interveners or consumer advocates over the years?
I have.
Okay. And isn't it fair to say that in all those...
Mr. Cleaver.
Yes,
Mr. Cleaver, I'm
Doug.
sorry.
Yes, Doug.
You are cutting off and on. Either get closer or maybe that door's closed. I don't know.
Is that better, Doug?
Sounds better. Let's try.
Okay. Mr. Gibson, I had asked, over the course of your time at Washington Gas, you've reviewed, is it fair to say you've reviewed dozens of testimonies from witnesses for consumer advocates and other interveners?
That is true.
And isn't it fair to say that in those testimonies, the witnesses identify some, but not all, of the components of the company's case with which they disagree and for which they propose a disallowance or an adjustment?
That their testimony contains a narrow set of issues? Yes.
Yes. Okay. And when you say here that the material ones are, and again, I'm just back on page 12, the part we've already read. When you say the material ones are unrelated to any genuine reduction in cost, what do you mean by genuine reduction in cost?
I mean, they are not related to a reduction in test year or future operating expenses of the company, what the company will require in order to deliver safe and reliable service to customers.
So what you're saying is that you're criticizing Mr. Coppola's adjustments because he's proposing to remove expenses that the company has actually incurred and may incur in the future?
Objection, Your Honor.
What is the basis of your objection?
The basis of the objection is that Mr. Cleaver is trying to testify in this case.
Overruled.
Could you repeat your question?
Yeah, I asked you, you explained, if I understood your answer correctly, you explained that by genuine reduction in cost, you mean that the items identified by Mr. Coppola are actual expenses that the company incurs or may incur in the future. And so then I was following up with you and asking you, so one of your criticisms of Mr. Coppola's adjustments is that they don't represent actual cost reductions for the company?
That's correct.
Okay. All right. Thanks. I wanted to confirm that. If I could take you down to page 13.
I'm there.
Okay. Bear with me a second. You're again talking about the, you're still talking about here, Mr. Coppola's adjustment based on incentive compensation. And you say here at lines 4, I'll start at line 4. OPC witness Coppola offers no testimony demonstrating that the company's compensation for employees is out of the ordinary or not in line with market. And then you say, as joint company witnesses, Rodriguez and Stuker, forgive my pronunciation, demonstrate total compensation is both reasonable and market-based. Mr. Gibson, you would agree that in past instances where the commission has disallowed incentive compensation, at least for Washington Gas, it's not been based on a finding that the compensation was out of the ordinary or not in line with market, wouldn't you?
I would.
Okay. And that's not the standard that this commission has applied in determining whether or not it's appropriate for ratepayers to pay incentive compensation, correct?
Objection, Your Honor. Your Honor, this is asking the witness to provide a legal basis or a legal opinion, which Mr. Gibson is not able to do.
Not asking for a legal opinion, Your Honor. Asking him if he knows what. Thank you.
Overruled.
It is out of the norm. Generally speaking, test year costs are included in the cost of service based on whether they are reasonable and whether decisions to incur them were prudent.
I'm sorry, what's out of the norm?
Out of the norm is not making that consideration, the reasonableness and prudent consideration. But that it is out of the norm, but the commission does not consider that the compensation is reasonable and market-based and doesn't require that the company change its compensation programs. It simply states that financial performance measures should not be recovered in rates.
Thank you. And so when you say here at line 8 to 9, still on page 13, it is odd that a single component of pay would be controversial when others are not. You're talking about the commission policy?
I'm talking about the general controversy that occurs in cases over compensation.
Mr. Gibson, lean in closely when you speak.
So
I am referring to the general controversy that occurs in cases regarding compensation.
Okay, so you think the controversy is odd. I take that to mean that you also think the commission policy is odd. Is that fair to say?
Objection, Your Honor.
Your Honor, these objections that don't have, where a basis is not stated, none of which have been sustained, I would.
Well, first of all, you're asking his opinion about.
Mr. Kane, your objection is sustained.
Thank you.
Thank you, Your Honor. I'll move on. Mr. Gibson, you then continue on and say, and I'm still on page 13. I'm down on line 15. What is the result of denying the company recovery of a component of its total compensation costs incurred in providing utility service? And your answer, I'll read the first two sentences. The result is that the company is denied the opportunity to earn its authorized return. Alternatively, it is circuitous. That's another typo, I guess, right? That should say it is a circuitous way. Is that
Correct.
right? Okay. It is a circuitous way of effectively reducing the return the company earns on rate base. I mean, that statement that you make there, that's applicable to any expense item that the commission disallows in a case, correct?
Objection.
What's the basis for the objection?
Your Honor, he's asking an opinion that is basically not relevant and can go to any opinion.
Overruled.
Any test year operating expense that is denied would not allow the company to earn its authorized return. That is true.
Right. So this statement would apply to something that's almost universally disallowed from recovery, such as lobbying expenses, correct?
I wouldn't characterize it that way because those are below the line costs. I'm only speaking here to items that are above the line.
But they're below the line costs are below the line because of regulatory bodies' decisions that they're not properly recoverable from ratepayers, correct?
Objection, Your Honor. Mr. Cleaver again is testifying.
Overruled.
Amounts below the line would be included in the GAAP reported earnings and would be a reduction in GAAP return. Yes.
Thank you. Going down a little bit more, you say on line 22, considering that OPC is also recommending a 70 basis point reduction from the company's current authorized return, and also proposing a hypothetical capital structure with greater leverage, it is clear that OPC is not, going on to page 14, interested in providing the company a just and reasonable return on the company's rate base. Do you see that?
I see that.
Okay. When you refer to a 70 basis point reduction, you're referring to the difference between the company's last awarded ROE, which was in case number 9481 in 2018, which was 9.7, the difference between that and the 9.0 ROE that OPC's cost of capital witness David Garrett recommends in this case, correct?
Yes.
Okay. The company's cost of capital witness in this case recommends a 10.45 ROE, correct?
Yes.
Okay, and that's 75 basis points above what the commission deemed appropriate, correct?
That wasn't my point here. I'm pointing to the current authorized return. But yes.
Okay. And do you agree that the concept of just and reasonable considers not only the interests of the company, but also the interests of the company's customers?
Objection, Your Honor.
I didn't hear the last part of Mr. Cleaver's statement because he turned his face sideways. If you could ask the question again, and then I'll rule on the objection before the witness can answer.
Sorry, Your Honor, I agree. I asked Mr. Gibson if he would agree that the concept of just and reasonable, which he invokes here in his testimony on line 1, page 14, applies not only to the company, but to the company's customers.
What's the basis for the objection?
Your Honor, just and reasonable is a legal term, and Mr. Gibson is not a lawyer.
Okay. The witnesses testifying today are expert witnesses. There are some legal terminology that they need to know and that they use in their testimonies, and so I will allow the question.
I'm just using the words in my testimony based on their common English definitions. Your question about just and reasonable for customers, we have over 1 million of them. What is just and reasonable to each customer? I don't know.
Okay. Thank you. continuing down, I'm now just keep going next page, page 14. I'm want to ask you one more series of questions about this Q&A beginning on line 3. By the company achieving its authorized ROE, do customers benefit? You say absolutely they do. A financially healthy utility able to easily finance its operation is a benefit to customers that the commission recognizes. When the utility achieves its authorized rate of return, there's no need for rate relief or rate cases. Is it your testimony that the company under its current rates is not financially healthy?
Under its current rates? We filed a case because we require rate relief.
So under current rates, is the company financially healthy? I'm using your term.
Objection, Your Honor.
Basis?
Your Honor, he's asking Mr. Gibson a question that is outside the scope of his direct, and also he's testifying and badgering the witness.
Okay. The statement that just referenced in Mr. Gibson's rebuttal is a financially healthy utility able to easily finance its operations is a benefit to customers that this commission recognizes. When the utility achieves its authorized rate of return, there is no need for rate relief or rate cases. The attorney is asking a question based off that statement, and it is appropriate. Overruled.
Mr. Gibson, do you need me to repeat the question?
I do.
My question was, is it your testimony or is it your opinion that Washington Gas is not financially healthy under current rates?
That is not a statement contained anywhere in my testimony. It's beyond the scope of my testimony. So
you don't have an opinion on that?
the proper witness to answer that question would be Doug Bonowitz.
Fair enough. I'll move on. All right, let me ask this question, Mr. Gibson, again, just go on this discussion that you included in your rebuttal testimony. The company, would you agree that the company is able to provide safe and reliable service under current rates?
Under current rates? It can, but it's not achieving its authorized return, which is why we've sought rate relief in this case.
Okay, thank you. And the rates that are presently in effect are the product of a settlement agreement in case 9605, a Washington Gas base rate case filed in 2019, correct?
That's true.
And as I talked about with another witness yesterday, the company also filed a rate case in 2018, which resulted in a rate increase, correct?
That is also true.
Yeah. Your Honor, can I have your indulgence for a moment? Just want to review some notes. I'm wrapping up,
Yes,
but
sir.
I'd like to take a look. Thank you, Your Honor. No further questions, Your Honor. Thank you, Mr. Gibson.
Thank you. Staff? I believe you're muted, Mr. Wilson. I see your mouth moving. We've had some technology issues today.
Can you hear me now?
Yes, thank you.
Yes, wonderful. Well, the good news is I have no questions for this witness, Your Honor.
Okay, I'll turn it over to Mr. Kane for a redirect.
Your Honor, we just have one question on redirect. Mr. Gibson, did the commission exclude any of the capitalized benefit cost in setting the rate in the case that Mr. Cleaver was referring to?
No, it did not.
Okay. No other questions, Your Honor.
Thank you, Mr. Gibson, for your appearance this morning. You are released, and WGL can call its next witness.
Okay.
Thank you, Your Honor. This is Paul Buckley for Washington Gas. I believe the next witness we have in order is Maria Frazzini.
Can everybody hear me?
Yes, ma'am. Can you raise your right hand, please?
Great.
Do you swear or affirm that the testimony you're about to give is the truth?
I do.
Thank you. Your witness, Mr. Buckley.
Thank you, Your Honor. Good morning, Ms. Frazzini, and welcome to the Maryland Commission.
Good morning.
I'm going to qualify you on a couple of pieces of testimony, one of which I believe you're adopting. Is that correct?
That's correct.
So do you have before you a document that's entitled The Direct Testimony of Nicole Johnson, which consists of 22 pages and 5 attachments?
I do.
Actually, as a preliminary matter, let me go ahead and get your business title and address for the record. I neglected to get that.
Sure. I am the Director of Sales and Economic Development for Washington Gas.
And your business address, please?
6801 Industrial Road, Springfield, Virginia.
Thank you. Turning back again to the direct testimony of Ms. Johnson. Again, this is testimony that you are adopting. Is that correct?
That's correct.
And you're adopting in its totality, except for the individual items related to her personal, professional background, as well as her educational background and her history of testifying in regulatory proceedings, correct?
That's correct.
Have you reviewed this document?
I have.
And do you have any corrections to make to it or any of the attachments today?
I do not.
I would turn your attention, please, to the second document, which is entitled Rebuttal Testimony of Maria Frazzini. Which, do you have that, ma'am?
I do.
And that document consists of 17 pages of narrative questions and answers, along with 5 exhibits, correct?
That is correct.
Do you have any questions to make to that document today?
I do not.
If the questions asked in both of these documents were asked of you again today, along with the attachments, do you adopt them as your sworn testimony?
I do.
Your Honor, Washington Gas would ask that the direct...
Mr. Buckley, I'm sorry, you actually started cutting out a lot. Could you just lean a little closer to the computer and speak into it?
I'm sorry, sir. I put on a headset to try and help avoid that problem. Is that any better?
Let's give it a try.
Okay. Your Honor, Washington Gas would ask that the direct is anyone's microphone not muted that shouldn't be talking? Maybe that's no. Looks like it's just you and me, Ms. Frazzini. Your Honor, Washington would ask that the direct testimony of Maria Frazzini be marked for identification purposes. I believe we were up to WGL number 17.
You're correct. WGL 17 is marked.
And thank you, Your Honor, and that the rebuttal testimony be marked for identification purposes as WGL 18.
WGL Exhibit 18 is marked. Are there any objections to its introduction at this time? Hearing none, WGL 17 and 18 are admitted into the administrative record.
Thank you, Your Honor. There was no prepared oral rejoinder from Ms. Frazzini, so she is available for cross-examination.
Aoba, do you have cross-examination?
No questions, Your Honor.
GSA, do you have any cross-examinations?
No, Your Honor.
Montgomery County,
No, Your Honor.
OPC,
No questions for this witness, Your Honor.
and staff.
Good morning, Your Honor, and Ms. Franzini, Catherine Mackerlin, on behalf of staff, I have some questions for Cross, please. Good morning, Ms. Franzini, almost afternoon. We'll just jump right into it. Isn't it true that consistent with COMAR 20.07.04.08C, that in order for promotional advertising expenses to be allowable for rate-making purposes, the cost must provide direct benefits and be in the public interest?
That's correct.
Isn't it true in the last litigated rate case, CN 9481, the commission ordered the company to provide more information about the classification of each advertisement program, and to the extent it is not informational, to provide testimony regarding why it is directly beneficial to the ratepayers and in the public interest?
Yes, that is correct.
So you reference Commission Order number 88844 in page 11 of your rebuttal testimony. That order, the commission in that order described the educational material related to potential energy savings and positive environmental impacts as being in the public interest. And they also included educational programs directed towards manufacturers, HVAC contractors, and customers about natural gas compliances. These types of programs were found to be informational and presumed to be in the public interest, correct?
Correct.
On page 8 of your rebuttal testimony, you state that the public interest finding also included the company's promotional programs directed towards manufacturers, HVAC contractors, and customers about natural gas appliances, correct?
Correct.
The commission refers to the educational programs of the manufacturers, HVAC contractors, and defines them as informational when making the public interest finding, correct?
Correct. I mean, yes, we put a lot of informational content in our promotional marketing materials. So, you know, there's informational content that we provide and classify as such. And then there's information, because to meet the COMAR standard, we want to make sure that our material is in the public interest and it contains a lot of great, educational information about natural gas, operating costs.
I'm sorry, Ms. Franzini. Ms. Franzini, you're cutting off. Can you just lean in closer to the computer?
Certainly.
Thank you.
Okay, absolutely. And I'll try to speak a little slower.
Just a second, Mr. Buckley, I'm going to unmute you and you're going to have to, I'm going to mute you and you're going to have to unmute when you have an objection.
Okay.
Go ahead.
So our information, so there is sort of a crossover where we, in our promotional materials, because we provide such an extensive amount of information, like I was saying, to comply with the COMAR regulation, we, our promotional marketing in many cases could be classified as informational, but because we also are providing that information so that the target audiences, and that would be the HVAC contractors, direct customers, our partners, builders, have the information that they need to take the next step in the sales process. we classify them as promotional because they are going to ultimately result, or the intent is for them to ultimately result in customer acquisition.
Thank you.
Certainly.
It's true that there is a difference between the treatment of informational and promotional marketing expenses, correct?
Correct.
How do you define direct benefits as reflected in the statute?
So we define it as the benefits that the rate payers, the current rate payers, receive as a result of Washington Gas adding customers through our promotional marketing efforts. And I outlined those on page 15 through 22 of the direct. They're detailed, and then I have summarized them on page 17 of my rebuttal testimony.
Okay. That brings me to my next question. It's just an example. So the on-main marketing materials attached to Ms. Johnson's direct testimony as Exhibit NNJ-1 Schedule 3, those would be classified as promotional marketing costs, correct?
That's correct.
Isn't it true the company does not present data showing the number of customers that were added as acquisition as a result of the on-main promotional marketing program to the total of the 5,700 new customers added during the test year?
Well, I think let me just kind of level set a bit, because we certainly that information, but in a given test year, the information from that campaign is not necessarily directly tied to the customers who are contracted for or signed up in that same period. So, again, it's one touch point. It's the initial touch point. There are a number of steps that then are resulting from the sale that then continue in the sales process once a customer makes a decision to seek further information and contact the company. It's difficult to tie directly to any one of the promotional marketing campaigns as to what caused that customer to take the next step in the process.
Thank you for the patience. Just want to get this down.
No.
So, okay. But not all customers that connect to the system are directly attributable to the advertising programs, correct?
Well, that's something we don't really know. I mean, there's going to be, like I said, it is the promotional efforts are sort of the initial touch point. That's where we cast a wide net and we provide that very detailed information to the consumers so that they can make an informed energy choice. Then, they may take other paths to get to a final decision. But, I believe that the information is vital and it's the core to our marketing strategy, and is also very cost efficient to be able to communicate to a wide group of customers about the benefits of natural gas so that they can then take the next steps when they're ready to move forward to add natural gas.
Okay. So wouldn't you agree that incremental customer growth is a benefit to the ratepayer? but it's unclear whether the customer growth is caused by promotional advertising.
I agree that it's a benefit to the ratepayer. In my 3 decades of experience at the company and doing marketing, I know how essential it is that you communicate and promote the company's product, and natural gas is a complex decision for customers to make. So I don't know that you could say that, that it isn't an essential component of the customer's decision. Having that information out there is very important. I know that from, just speaking with customers, people need the information because they need to know how to take the next step. And, having the promotional advertising and marketing out there, which gives customers a lot of information, which is in the public interest. And it also gives the customers the direction of what is the next step for them to take in order to learn more and begin the sales process. And that sales process is a complex process. There's more to it. You can't just say, I wish it was that easy, but you can't just say that, well, this campaign resulted in the customer's decision, because then, we have to then, get a lot of other information back from the customer. We have to apply for permits. We have to evaluate the customer's distance from the closest main, provide them with a quote based on GSP 14 calculation. And then all of those factors are going to contribute to the customer's decision. The first and most important was getting the information out there so that they could then evaluate that decision. And that's what the promotional marketing that Washington Gas does in compliance with COMAR. And so that's why, I believe, we should receive recovery on those expenses.
Okay. On page 20 of Ms. Johnson's direct testimony, lines 11 through 24, it states that in 2019, the company's residential marketing efforts produced an overall response and conversion rate nearly 3 times higher than a pure natural gas utility. So you do try to measure the impacts of the marketing efforts, correct?
That's correct.
And further down on that page, it says, additionally, the company's multifamily campaign in 2019 produced a 3% conversion rate in line with industry standards of 3 to 5%. The campaign resulted in 766 potential project meters, and the email campaign produced a 33% open rate and 20% click-through rate compared to industry averages of 18% and 2.5% respectively, correct?
That's correct.
So not all 766 potential project meters were enrolled as new customers in the test year, correct?
I don't know that answer. I don't know what percentage of those 766 went on to become customers.
But you know the cost of the residential marketing efforts of the test year, correct?
I do, but customers don't come on. I think the point that I was trying to make is that the expenses that are incurred in the test year are not necessarily going to drive customers that same year. So I think, I don't know how many of those customers ended up, becoming customers out of that campaign or out of that particular metric.
So it's very difficult to track the enrollments as a result of spend on a certain campaign. Correct?
Well, right. Like I was saying, the information that we provide can result in, a direct tracking so that we can actually see what customers, how customers engaged with our material. But it isn't always going to be an apples to apples comparison as to which of those customers wound up actually installing natural gas.
So you can track how the potential customers engage with the marketing materials, but you can't track how the marketing materials directly benefit the current ratepayers.
No, I didn't say that. The way that the marketing materials benefit the way that our marketing efforts benefit direct ratepayers is because they ultimately yield new customers for the company. They are the initial step in the process. It's the initial touch point. It's air cover, if you will. It's having the information out there so the customer can then see it and take the next step if they are interested.
So you're saying that the initial contact or first step with a potential customer is the direct benefit?
No, and the direct benefit is the ultimate increase of new customers, which will, as I put in my testimony, yielded 20 million in incremental value, and having new customers, steady growth on the system better utilizes the company's facilities, and it helps to spread fixed costs over a greater number of customers. So it keeps rates down for existing customers. That's the direct benefit.
Okay.
For ratepayers, because that's the COMAR standard. So the COMAR standard is is both information that's in the public interest. I think we check that box quite easily because we have, as you see in the exhibits, a lot of really informative information in our promotional marketing. The direct benefits to ratepayers, the existing ratepayers, is in the reduced rates, or not reduced rates, but the reducing, the keeping, the mitigation of rates through the value that new customers bring onto the system that are generated from our promotional marketing.
But you can't identify the number of customers that are brought onto the system specifically by specific marketing programs, correct?
Usually, when you're measuring marketing spend, it's complex. As I discussed in my testimony, it's multi-channel, and a lot of customers seek information from a lot of sources to make a decision. So it isn't always a one-to-one relationship that can be easily tracked to a particular single campaign as to what caused a customer to make the decision to finally sign up. So usually you look at the spend and you keep that steady spend, and the value that spend results in is what contributes to the direct benefit to the existing ratepayer. And it dwarfs in comparison, $591,000 dwarfs in comparison to the 20 million in positive incremental revenue over 30 years that is resulting from that we gain each year from the number of customers we add to the system through our marketing efforts.
Well, I agree with you that it's a complex process, and it's very hard to illustrate the direct benefits. That's why no other utilities recover.
Objection, Your Honor.
Promotional costs.
Objection, Your Honor. The mischaracterizing the witness's testimony. Ms. Ferzini never said it was difficult to define that customers receive benefits from the marketing activities.
I agree with you. I'm not saying that you said that it's difficult to define benefits. It's difficult to define the numbers of customers that result from certain specific marketing campaigns.
Ms. McGurlin, will you rephrase your question, please?
Yes. So, the fact that no other utilities recover these promotional costs WGL is seeking to recover supports the rationale that it's difficult to demonstrate these direct benefits of promotional advertising required by COMAR, correct?
I don't necessarily agree with that. I don't know what the other companies' marketing strategies are or their growth plans. COMAR is a high standard. Putting all of that informational content in the materials that are sent out is a high standard. Companies don't necessarily, may not necessarily choose to do that. Washington Gas does. And we believe that complying with COMAR and providing which provides the direct benefits that we enumerated, along with having our content be in the public interest, is Washington Gas's strategy. I can't speak to the other utilities and what their strategies are. And Washington Gas has been successfully recovering these expenses, compliant with COMAR for, like I said, decades.
Correct. But in the commission's recent case, the commission ordered the company to provide more information about the advertising programs that, to the extent that it's not informational, to provide testimony regarding why it's directly beneficial to ratepayers and in the public interest, correct?
Correct, and that is what I did in my testimony, I believe.
So I just have a couple more questions here. So on page 4 of your rebuttal testimony, where you state the company added over 5,700 new customers, and those additions will produce approximately $20 million in contributions that will help mitigate or provide downward pressure for rates for existing customers over the 30 years. It can't be discerned how the amount spent on promotional marketing activities led to the specific increased sales in Maryland in total, or some directed effort, correct?
Could you ask the question again? I'm sorry.
Sure. So it can't be discerned how the amount spent on promotional marketing activities led to specific increased sales in Maryland in total or at some directed effort, correct?
It's a part of the overall sales strategy. The expenses that are incurred, or the expenses that are incurred through our promotional marketing campaigns are a component of the customer sales that the company achieves each year.
Okay. And WGL compares the success of its marketing campaigns to the comparison of other utility advertising campaigns, correct?
Well, the examples we just spoke about were a couple of points that we highlighted to show that our efforts are efficient and that they're prudent and successful.
Okay, and WGL, they conduct many forms of research and analysis to assess the competitive landscape, including the natural gas preference survey and the partner builder survey.
I'm sorry. Your question was all cut up. You're gonna have to start over again and make it loud.
Okay.
I'm sorry.
Thank you. WGL does conduct many forms of research and analysis to assess the competitive landscape, including the natural gas preference survey and a partner builder survey, to better understand the process to bring natural gas to their projects. is an illustration of some of these surveys, correct?
The company does the surveys that you referenced for a number of reasons, and part of it is also to help inform the content that is included in our informational and promotional marketing so that it does meet the customer's needs. So yes, we do studies for a lot of purposes.
But these studies are not a specific analysis of the costs and benefits of specific advertising campaigns, but are broad surveys, correct?
I'm just thinking, I just want to make sure I answer you correctly. The surveys that were identified in my testimony are surveys that assess the preferences and the process of our marketing efforts. Yes, broad marketing efforts. Yes.
Okay, thank you. I have no further questions.
Mr. Buckley, do you have any redirect?
Thank you, Your Honor. Yes, I do. Hello, Ms. Frazzini.
Hello.
Do you recall at the beginning of the series of questions from counsel for staff that you were discussing the provisions of COMAR, the elements of COMAR related to the various qualifying categories such as information provided to customers?
I do.
So to try and help delineate that, I'm going to ask you if you can turn please to your direct testimony at page 3.
Mm-hmm.
And I want to see if we can get rid of a little bit of confusion between the word information that's described there in COMAR and the extensive use of the word information as you describe it in your marketing materials.
Okay.
So if you look at page 3 of your direct testimony, you see the 4 subcategories of COMAR, correct? Which includes under number 2, informational.
Correct.
Now, if you turn please to page 4, and again, this is trying to clarify your conversations with staff counsel, you do describe what that specific COMAR category of informational, and I'll use capital I, for example, to try and distinguish
Okay.
it. So can you just give us an example of, for under that COMAR category, which is not at issue in Mr. Valcarengi's testimony, what's normally included as informational to qualify there?
Sure, and I have attached some samples in my exhibits. That would be information about 811, the call before you dig, safety, compliance information, which is our Always Safe newsletter, and information such as that speak to safety primarily. And
So now, okay, thank you. And so switching to the other usage of the word information, which I heard from you in your conversation with staff counsel, if you look at page 5,
mm-hmm.
when you start to discuss the marketing category under COMAR,
Yes.
at lines 11 and 12, you say provides key information. So distinguishing small I, can you explain what that information is, what that role is, and what the benefit and how it leads to increased sales, if you could?
Sure. The information that we provide in our promotional marketing is in the public interest. That's to, so that we are, complying with COMAR and providing information that is in the public interest. And that includes operating cost information, comparison with other fuels, information about high efficiency appliances, cost savings, and also steps for the customer to know how to take the next step in the process to become a customer.
To educate customers, if you will.
And to educate customers, correct.
So can I get you to turn, please, to page 15 of your rebuttal testimony?
I'm sorry, Mr. Buckley. I'm not picking you up. Mr. Buckley,
Yeah.
I'm not picking you up at all. And you're cutting off and on. Could you speak a little louder or lean into the computer?
Okay.
Or is it on your headset?
Well, I've got it on the headset, so I'm trying, Doug. I'm trying. So is that any better? I'm speaking louder.
It's just that it's a tough situation to handle because of all the people. So I understand that you're having a problem. Just give it a shot.
Okay, sir. Ms. Frazini, at the top of page 15 of your rebuttal, do you see that quote from a commission order in case 8959?
I do.
And the first sentence talks about his finding
Mhm.
that marketing expenditures are necessary and appropriate expenses which benefit customers.
I see that.
Can you read the very next sentence, please?
Sure. The provision of information is, in and of itself, beneficial to customers and potential customers who can evaluate the information provided by the company and that provided by competing energy sources and can then make an informed decision.
And does that describe the same information that you have provided in support of this test year expense, the educational information provided directly to customers for them to make educated decisions?
Yes, it does.
Your Honor, if I could just have a moment, I just want to make sure that there's nothing else I need to cover.
Yes, sir.
Oh, I do have one other matter. Ms. Frazini, can I get you please sticking with your rebuttal testimony?
Mm-hmm.
I would ask you to turn please to your first rebuttal exhibit. That's MTF-R1.
And is that, could you give me the data response number that is?
Of course. It's 8-15.
Yes, I'm there.
And on the second page of that, in the middle of the page, there's a categorization called Residential Conversion Survey Conclusions.
Yes.
And do you recall during your questioning from counsel for staff the description, a discussion of various surveys performed by the company related to the effectiveness of its marketing campaigns?
I do.
So at the second bullet, there's a description of the majority of respondents cited the company information that it influenced their decision to convert to natural gas.
I see that. Yes.
Is that an example of those surveys?
Yes, it is. That would be our conversion, our residential conversion survey. 70% of the respondents cited that the information they received influenced their decision to convert to natural gas.
And what does that mean, if anything, to you regarding the effectiveness of the company's surveying efforts in convincing customers to take natural gas?
It tells me that it's vital to have that information out there.
Thank you, Your Honor. That concludes the redirect of Ms. Frazini.
Ms. Frazini, I don't have any questions for you. Thank you for your appearance this morning into this afternoon.
Thank you, Your Honor.
Parties, we're going to take a 5-minute break. Master Court Reporter, I'm going to ask that you go offline and then re-log in. This morning, I am not having any trouble hearing the questions from Mr. Buckley. And so I'm wondering if perhaps the issue is the bandwidth on your end or your connection. So while we're on the 5-minute break, while we're off the record, I would ask that you go offline and then come back on and see if that fixes the problem.
Will do.
Thank you, Doug. We're off the record for 5 minutes. Thank you, everyone. Mr. Court Reporter, do you need anything from me to check your system?
Yes, I just wanted to see if you could hear me well, and I wanted to test someone's audio, so I can hear you okay. Can you hear me?
Yes.
Is there any delay?
There is no delay. Earlier, it was very choppy, and I think all the parties could hear the witnesses' questions, but Doug could not.
Okay, so I'm gonna stand by and just listen to everyone. It sounds like it's okay on our end. I did hardwire internet the computer in, so that should take away the delay.
Okay, Mr. Buckley, are you sitting at your computer?
I'm not sure if he's available right now. I'm sitting at my computer, if that helps.
Mr. Buckley was the one who the court reporter had trouble hearing just now, so I was hoping, but that's fine.
I apologize.
Ma'am,
Hi, Mr. Buckley. My name is Sabrina. I'm tech support. We just wanted to test your audio here to make sure we can hear you okay.
Of course, Sabrina. Good afternoon. How you doing today?
I'm doing well, thank you.
How's that sound?
Sounds great to me. I'm gonna stand by just in the background to make sure, but it sounds okay to me. And if anything happens, I'll jump in.
Well, I appreciate you coming in and correcting that. Thank you so much.
thank you very much.
You're welcome.
Okay, Mr. Dodge, do you have another witness?
It turns out we do have another witness, and a couple of more after that, as it turns out, too. The
We may
Washington
need
Gas.
to have a discussion at some point. What's going to happen if we don't get through all of our witnesses today?
Yes, actually, I do have a preliminary well, it can wait. It's not. I haven't fully formed it, but yes, it was along the lines of what you were going to raise right there.
Okay.
It does not involve weekend hearings. I assure you.
Everyone can think about that, and we'll go ahead and handle the next witness. We can go on the record.
We're on the record, Your Honor.
Okay, and you sound great, Doug. Thank you. Go ahead, Mr. Dodge. Call your next witness.
Thank you, and you look great too, Doug. Washington Gas calls Frederick Morrow to the stand.
Mr. Morrow, can you hear me?
Yes, I can.
Okay, I see you've raised your right hand. Do you solemnly swear that the testimony you're about to give is the truth?
I do.
Thank you. Can you spell your first and last name? And I guess, I'm not sure, is that any additions to your name for the court reporter, please?
Sure. First name is Frederick, Frederick. Last name Morrow, Morrow, and I'm the third, so 3 capital I's.
Thank you. You're a witness, Mr. Dodge.
Thank you, Your Honor. Good afternoon, Mr. Morrow. Can you hear me okay?
Yes, I can, Mr. Dodge. Thank you.
Thank you. By whom are you employed, sir?
Washington Gas Light Company.
How long have you been employed by the company?
This coming May will be 17 years.
What is your current position with Washington Gas?
I'm the Director of Construction for Maryland and the District of Columbia.
Mr. Morrow, are you the same Frederick Morrow who caused to be filed on December 8th of calendar year 2020 rebuttal testimony in this proceeding?
Yes, I am.
Am I correct, sir, that your rebuttal testimony consists of 40 pages of narrative questions and answers?
Yes.
Am I also correct that there are 3 exhibits appended to your rebuttal testimony?
That is correct.
Is there any confidential information in either your rebuttal testimony or your rebuttal exhibits?
No, there's not.
Your Honor, I believe we're up to number 19 for marking purposes, and I would ask that Mr. Morrow's rebuttal testimony exhibits be marked as WGL 19.
WGL 19 is marked. Are there any objections to its admission at this time? Without objection, WGL 19 is admitted at this time.
Thank you, Your Honor. Mr. Morrow, was your rebuttal testimony prepared by you or under your direct supervision or control?
Yes, it was.
At this time, do you have any corrections or edits to make to your rebuttal testimony or your rebuttal exhibits?
Yeah, I have 2 minor corrections. On page, I'm sorry. On page 4, line 3, the sentence should read, My testimony is organized to address issues raised by OPC witness. I omitted the word by. And then I do have a second minor correction, which is on page 17, line 10. There should be a period after the word project, which is the second to last word in that line. And that's all the changes or corrections that I had.
Thank you, Mr. Morrow. If I asked you the questions which appear in your pre-filed rebuttal testimony today, would your answers be the same?
Yes, they would.
Do you adopt the testimony as your own in this case?
Yes, I do.
We do have a bit of rejoinder testimony from Mr. Morrow, if I may, Your Honor.
Go ahead, Mr. Dodge.
Thank you. Mr. Morrow, in OPC witness Coppola's surrebuttal testimony, he references in a number of places jurisdictional requirements. Are you aware or do you remember his reference to this concept of jurisdictional requirements?
Yes, I am.
Can you please explain for the record what the term jurisdictional requirements or requirements means in the context of this case and the company's construction projects?
Yeah, yes, I can. There's two categories in which the company references jurisdictional requirements. First, are the permitting requirements. In general, the majority of the company's distribution work is permitted to be performed during normal daylight hours. There are some instances the jurisdictions will require the work to be performed at night. This is a decision that's made by the permitting agency, and it's not always a one-size-fits-all scenario. The company's experience, where we're working in large intersections or busy roadways, and the company's been permitted to work during the daylight hours. And we have experience with similar types of intersections or roadways where the company has been required to work at night. And the second category of the jurisdictional requirements that we reference is around paving, and each jurisdiction does provide guidelines in their regulations for the paving limits. However, once the work has been completed, the jurisdiction's inspector has the final say on what the final paving restoration limits will be. So when the construction project has ended, the company will set a meeting with the State Highway Administration, Montgomery County Department of Transportation, the Maryland Department of Transportation, Prince George's County, or any other jurisdictions, inspectors in which we work, in order to mark out the final limits of paving restoration, which obviously can't take place until the construction has been completed.
Thank you. If these paving restoration limits are increased, does that mean that the contractor moves to a time and materials payment schedule as OPC witness Coppola suggests in his surrebuttal testimony?
No, it does not. As stated throughout my rebuttal testimony, the company utilizes the competitively sourced contracted unit rates to complete the required work. So if the limits are increased or decreased, the contractor only gets paid for the units that they have actually restored.
Is that also the case for changes that may be necessary while performing underground work as well?
Yeah, yes. The company follows the same well-defined cost management processes that I described in my rebuttal testimony. For example, if the main installation footage needs to increase due to an unknown underground structure, the underground contractor will utilize their competitively sourced per foot unit rate to complete the necessary installation after receiving approval from company management personnel.
Thank you. Are all of the charges associated with projects performed on the distribution system reviewed and approved following a formal process?
Yeah, absolutely. As stated in my testimony, the company has a well-defined formal process to document, review, and process only that which is necessary and appropriate to complete each project.
OPC witness Coppola also in his surrebuttal testimony at page 15 and pages 15 and 16 states that company witness Esmacher, who will follow you here today, we hope, is at odds with other company witnesses on certain concepts. Do you recall that testimony?
Yes, I do.
Can you please explain for the record the difference between how transmission construction and distribution construction projects are estimated and why?
Yes, I can. Distribution construction projects are estimated using historical average costs. The company has made enhancements to the estimating process over the recent years to include pipe sizes and service lengths to increase the accuracy of these high-level estimates. But due to the generally these projects are smaller in scope and repetitive in nature for the distribution work. So the company has made a conscious decision to utilize the method of estimation that we do, utilizing our cost management controls that we have in place to perform this body of work. The key is to replace the relatively higher risk pipe segments and utilize the qualified underground resources while having the ability to accommodate any field changes through the construction oversight procedures with the application of the competitively sourced standard unit rates, and also utilizing our well-defined pay item definitions, which is also discussed throughout my rebuttal testimony. On the other hand, transmission construction does not use historical estimates for their projects. The transmission projects are generally larger in scale. They're not as repetitive in nature, and the qualified resources may or may not already be performing that specific type of scope or work on our system. For these reasons, the transmission projects have a site-specific estimate that is created.
I need to interrupt for a second, Mr. Dodge. Did you say that the estimation process has been updated recently to include pipe sizes and service? Did you say lengths?
What I had mentioned is over the last couple of years, just through the different hearing procedures and working with the Office of People's Counsel as well as commission staff, we've tried to make updates to our historical averages where we've broken them apart. Before it was just a service was a service. Now we're breaking them apart where we'll break it up that a 3/4 inch service will use a historical average for 3/4 inch service. If it's 2 inch or larger, we'll use a different estimate for that. Same with main. Prior to years ago, we just had a foot of main was a foot of main. Now we break it apart where and the average cost for 2 inches utilized if we're installing 2 inch and so on and so forth.
Thank you. Thank you for that clarification.
Sure.
Well, thank you, Your Honor. That's all we have for live rejoinder, and Mr. Morrow is available for cross-examination.
Ms. Francis, do you have cross-examination?
No, I do not for this witness. And if it helps with everybody's planning, the only other witness for Washington Gas that we have questions for is Stephen Price, unless something else comes up during the hearing. So I don't know if that'll help anybody planning their time, but that's all the Washington Gas witnesses will be crossing.
Thank you, Ms. Francis. I'm gonna only ask you for cross on Mr. Price. So if there's another witness that something comes up on testimony, go ahead and wave to me or break in and interrupt me, okay? Thank you. GSA.
GSA does not have any questions. We also don't anticipate having questions for any other of the company's witnesses if that helps move things along.
Okay, same things goes for you, Ms. Singleton. Interrupt me if I skip over you inadvertently or on purpose. Ms. Brennan.
We have no questions for this witness, and like Ms. Francis, the only other Washington Gas witness at this time that we have questions for is Mr. Price, if that helps with planning.
Thank you. Office of People's Counsel.
Yes, thank you, Your Honor. Good afternoon, Mr. Morrow. Nice to see you again.
Good afternoon, Mr. Cleaver. You as well.
Mr. Morrow, I was just looking at your rebuttal testimony this morning. You are not an engineer, is that correct?
That's correct.
Okay, thank you. And I just had a couple of questions for you, I think. If I could ask you to turn to page 15 of your rebuttal testimony.
Okay.
And they're starting. I'm getting a lot of feedback from a microphone. I'm not. Maybe it's Mr. Morrow. Yeah, it doesn't. I guess you need to have your mic.
Mr. Cleaver, it's coming from his microphone.
Okay.
I can mute until I answer.
If that's okay with you, Mr. Morrow and the judge, that's fine. I can live with it if you want to have your mic on. I understand you're on this hot seat, so to speak. So, however.
He just muted and all of the interference is gone. So it will just take a little time to mute and unmute, but I think that would be great. Thank you.
Okay, thank you, Your Honor. Thank you, Mr. Morrow. Mr. Morrow, I'm looking at page 15 of your rebuttal testimony. And there you address OPC witness Coppola's testimony on 6 construction projects that you describe, line 14, as necessitated by the activities of entities such as the Maryland Department of Transportation and municipalities. And you address Mr. Coppola's position that those do not qualify as safety-related projects. Correct?
Yes, that's correct.
Thank you. And these projects here are projects that, or at least some of these projects are projects where costs were incurred outside of the 12-month test year that's been presented in this case. Is that correct?
I'm not positive on that answer, Mr. Cleveland.
Fair enough. It is fair to say, though, that your testimony expresses your view that these projects are safety-related projects, correct?
Yes, that is correct.
Okay. And what these projects entail typically is projects where...
Mr. Cleaver, this is Doug again. I apologize. I'm getting you cutting off and on still. Could you lean in a little bit closer to the computer, please?
Sure. Sorry about that. Does that seem better, Doug? All right. Let me give it a shot. Doug, tell me if there's a problem.
I'm trying. I'm sorry about that. I hate to interrupt anybody, but I want to get to all this.
Understood. I apologize.
It's not your fault. Nobody's fault. It's just it is what it is. Thank you.
Sure. Mr. Morrow, this is where there is these projects that you're talking about here, responding to Mr. Coppola's testimony. These are projects where the company is required to relocate some of its infrastructure or facilities because of work, paving work, for instance, done by the Maryland Department of Transportation that requires those utility facilities to be relocated. Is that a fair summary?
In some instances, yes. In other instances, no. Based on some of the work that they're performing around our facilities, we have experience where after that work's performed, it actually creates leaks on our system. So I wouldn't necessarily just say it's necessitated only because it's in conflict and needs to be moved because of their work. But sometimes it is, and like I mentioned, the extent of the project will be increased based on the materials that they're working around and the safety risk associated with that.
Okay, no, thanks for the clarification. So for these 6 projects that Mr. Coppola talks about that you respond to here, was the primary purpose of any of these 6 projects to address a leak that arose as a result of the work of Maryland Department of Transportation or some other similar agency?
No, we work with them prior to them performing the work so that we can avoid any future leaks.
When you say to avoid future leaks, do you mean that you're concerned about a situation where some piece of construction equipment doing work associated with a roadway might strike or damage a company pipe?
There's always that aspect out there, Mr. Cleaver, but also when you're excavating and disturbing the ground around those facilities, obviously the ground shift can create a leak or damage to our facilities.
Okay, thank you. But is it fair to say that it's a preemptive decision in order to avoid the possibility of a leak with respect to these 6 projects? Is that right?
That'd be a factual statement.
Thank you.
Yes.
Thank you, Mr. Morrow.
You're welcome.
Aside from a motivation to avoid the possibility of a leak, some of these projects the company is simply required to do as a result of the terms of the right-of-way that it shares with these other agencies. Is that fair to say?
That's correct. If the project that they're undertaking is going to have a conflict where our facilities are placed, we are required to perform that offset, if you will, or to alleviate the conflict. So we'll work with the jurisdictions to try to mitigate any of those instances, but when we can't, yes, we have to relocate our facility.
Okay, and do you know, I must confess, I don't know if this is in the record. Do you know of these 6 projects, whether any of those were required projects for the reason that we just established, that the terms of the right-of-way or easement, the company didn't have any choice. It had to embark on this project?
I don't have the details of every single project. If everyone had a conflict, I just know that they were driven because of the work that was going to be undertaken and the avoidance of future any issues or leaks that we have experienced on other projects. So I don't have the details of every single offset conflict. I just have the knowledge of the project that was undertaken.
Okay. Thank you, Mr. Morrow. That's all the questions I had for Mr. Morrow. Thank you, Your Honor. Thank you, Mr. Morrow.
Thank you, Mr. Cleaver. Thank you, Your Honor.
Staff have any cross-examinations for Mr.
Staff
Morrow?
has no cross-examination, but thank you, Your Honor.
Thank you, Mr. Wilson. Mr. Dodge, do you have redirect?
I have 2 very short clarifying questions, if I may, Your Honor. Mr. Morrow, can you still hear me okay?
Yes, I can.
That's wonderful. You just had a discussion with counsel for OPC regarding AOP, or advance of paving requirements. Is that correct?
Yes, that's correct.
I guess I can condense this to one question. You referenced the fear of a potential or future leak by having either a direct strike by a third party or shifting ground soils and so forth. Is that correct?
Absolutely correct, yes.
Is it only leaks that the company is worried about when it makes these safety-related changes, or are there other possible, whoops, my apologies, Your Honor, I'm back in my office. We traded in the glare of my study for the darkness of my office. I was asking Mr. Morrow, is it only leaks that the company is worried about, or are there other potential safety-related conditions that can arise from a regulatory authority or a local jurisdiction disturbing the soil near our facilities?
Yes, that is an issue that we have encountered before when there's work being performed around some of our facilities. with the ground shifting, it will create a leak, whether it's from the coupling, if you will, and the shifting of the pipe, or the disturbing even, a cast iron facility, and the shifting will get a leak on the joint. So there's a number of issues other than just a possible strike that we have experienced and have seen happen in the past.
Was one of those instances in the District of Columbia?
A few have been in the District of Columbia, and we have experienced some in Maryland as well.
Thank you. That's all that I have, Your Honor.
Mr. Morrow, I don't have any questions. I'm thankful for the additional testimony by you and other witnesses on the issues of cost overruns, and I thank you for your time.
Thank you, Your Honor.
Thank you. Mr. Dodge, do you have another witness?
We do. Our next witness is Wayne Akis, and I would call him to the stand.
Here?
Is it pronounced Akis?
Akis.
Akis. Okay. Mr. Akis, will you raise your right hand, please?
Sure.
You swear or affirm that the testimony you're about to give is the truth?
Yes, I do.
Will you spell your last name for the court reporter, please?
Jacas as in Sam.
Thank you. Mr. Dodge, your witness.
My cursor disappears quite often once I mute, so I apologize for that slight delay, Your Honor. Good afternoon, Mr. Akis.
Good afternoon, Mr. Dodge.
By whom are you employed, sir?
Washington Gas.
How long have you been employed by the company?
This May will be 4 years.
What is your current position with the company?
Director of Construction Program Strategy and Management.
Mr. Akis, are you the same Wayne Akis who caused to be filed on December 8th of 2020 rebuttal testimony in this proceeding?
Yes.
Am I correct, sir, that your rebuttal testimony consists of 21 pages of narrative questions and answers?
Yes.
Am I also correct that your rebuttal testimony has appended to it 4 rebuttal exhibits?
Yes.
Do either your rebuttal testimony or rebuttal exhibits contain any confidential information?
No, it does not.
Your Honor, I would ask that Mr. Akis's rebuttal testimony be marked as WGL 20.
WGL 20 is marked. Is there any objection to its admission? WGL 20 is admitted at this time.
Thank you, Your Honor. Mr. Akis, was your rebuttal testimony prepared by you or under your direct supervision or control?
Yes, it was.
Do you have any corrections or other changes to your rebuttal testimony or your exhibits at this time?
No, I do not.
If I asked you the questions contained in your pre-filed rebuttal testimony today, would your answers be the same?
Yes, it would.
Do you adopt this testimony as your own in this case?
Yes, I do.
Thank you, Mr. Akis. We do have a very brief rejoinder for Mr. Akis, if I may, Your Honor.
Go ahead, Mr. Dodge.
Thank you. Mr. Akis, at pages 42 through 49 of OPC witness Coppola's rebuttal testimony, did he discuss in general the disallowance of costs associated with certain STRIDE projects?
Yes, he did.
Are STRIDE projects approved by the Commission?
Yes, they are.
Now, help me out here. Is all design work completed on STRIDE projects on a calendar year project list before submittal?
No, most projects, if not all projects, are not 100% design. In fact, this was discussed with OPC and other parties at last year's technical conference. As a result, the parties had agreed to allow the company to update its estimates after final design and before start of construction for variance analysis.
Did the company provide variance explanations or analyses associated with these projects previously?
Yes, we have.
And where or how did the company provide those cost variance explanations?
The company provided the variance explanation in the semi-annual report, annual report, and all approved projects.
If you recall, only if you recall, did any of the interveners or parties in case number 9486, that would be the company's STRIDE 2 case, question the variance explanations provided for the STRIDE projects therein?
To the best of my knowledge, no. No one did include an OPC question variance explanations.
I hope I have my numbering correctly. I've been trying to keep up with the exhibit lists of the parties. I believe on OPC Exhibit 9, which is OPC Data Request 10-1, question C, OPC requested a split of the costs on the projects in question. Do you recall that data request?
Yes, I do.
Were those splits provided for each project?
Yes, those splits were provided in the semi-annual filing with the commission, which OPC receives in attachment H.
And when you say OPC received, you mean that the information was supplied in case number 9486?
That is correct.
Last bit of rejoinder, Mr. Ackus. On page 45, lines 12 to 14 of OPC witness's direct testimony, he seems to have assumed that 14 feet of pipe made up the additional $190,000 in variance on BCA, which stands for Business Case Authorization 282918. Is that a correct assumption?
Objection, Your Honor. This is a question about the witness's direct testimony. The time to respond to it was the company's rebuttal.
Just for clarification purposes, we're happy to let it go.
Okay, that's fine. Let's move on.
That's all we have, Your Honor. Thank you.
I'm going to skip over Iowa, GSA, and Montgomery County if they don't have any questions. If not, wave your hand and ask OPC. Do you have any questions on on cross-examination?
Yes, Your Honor. Thank you. Good morning, Mr. Ackus.
Good morning, Mr. Cleaver.
Afternoon,
good
I guess.
afternoon.
Sorry.
Good afternoon, Mr. Cleaver.
We both thought it was morning. Nice to see you again.
The same here.
If I could begin by asking you to take a look at your rebuttal testimony.
Okay.
And I want to ask you about a sentence beginning on page 3 at line 22.
Okay.
And here you're addressing Mr. Coppola's opinions about the company's cost estimation procedures. And you say, again, I'm on page 3, line 22, that assessment is flatly contradicted by OPC witness Brendan Larkin Connolly in case number 9486, where he stated in relevant part, quote, I find this general process of using unit costs and projected replacements, now I'm on page 4, to estimate a budget to be a reasonable approach to budgeting the 5-year Stride 2 plan. Do you see that?
Yes, I do.
Yeah. That testimony, actually, let me just, for the record, 9486, that's the company's Stride 2 proceeding where the company presented its second 5-year Stride plan to the commission, and then there were hearings and the commission issued an order on it. Is that right?
Yes.
Yeah. In that case, when Mr. Larkin Connolly made that statement, he was, and you can see it here in the words, you would agree that he was talking about the process of budgeting for a 5-year plan, right?
Yes, he did say budgeting, yes.
Yes. And what Mr. Coppola is talking about in his testimony is the way that individual project estimates are arrived at, correct?
Yes.
Yeah,
to the best
thank
of my
you.
knowledge, yes.
Thanks. Before I go further, let me go back. Something that you talked to your attorney about in rejoinder just a minute ago. Mr. Dodge asked you whether the commission approves the company's Stride project lists. Do you recall that?
Yes.
And you also, Mr. Ackus, discussed how certain information regarding cost overruns or variances, as different people call them, has already been provided in certain required Stride filings. Do you recall talking to Mr. Dodge about that?
Yes, I recall talking that is provided in a semi-annual and annual report to the commission and all the parties.
Yeah. And Mr. Akis, you've been to a number of administrative meetings before the commission where various matters related to the company's STRIDE program have been at issue, correct?
Yes, I have.
And in fact, we've seen each other there multiple times, right?
That is correct.
That's true. I'm not asking you for a legal opinion, but do you recall hearing statements from the commissioners that the time to assess the prudency of STRIDE projects is when the company chooses to move them into base rates in a base rate case? Are you familiar with that? Comments like that?
To my best of my knowledge, yes, I am.
Okay, thank you. If I could take you back to your rebuttal testimony and ask you to go on to page 10.
Okay. I'm there.
Okay. You're starting up at the top at line 1. You're speaking specifically about one particular project, BCA 0280602, and you indicate that you do not agree with Mr. Coppola's conclusions about that project.
Mr. Cleaver, I'm sorry, I missed the page reference. Could you repeat it for me?
It's page 10, Mr. Dodge, and I'm at the top at line 1. This is Mr. Akis's rebuttal testimony. Is everybody there?
If you're waiting for me, I'm there. I'm sorry.
Oh, okay. Yeah, no, I think good. Okay, Mr. Akis, you say there, after stating that you don't agree with what Mr. Coppola says about that project, you say, I'm on line 4, it is evident that OPC witness Coppola is unfamiliar with practical construction activities and the company's obligations to abide by the Maryland State Highway Administration specific requirements which have driven the cost on this project above the historic average. Let me ask you a question about this, the first part of that statement, that it's evident that OPC witness Coppola is unfamiliar with practical construction activities. Have you reviewed Mr. Coppola's rebuttal testimony?
Yes, I have.
Okay. And specifically, did you review the section of his rebuttal testimony at pages 11 to 14, where he discusses his decades of experience working for gas utilities and his involvement in the oversight of various types of gas pipeline and other gas infrastructure projects?
Yes, I reviewed it, and yes, I reviewed it. Go ahead.
Okay, and does that change your view of whether Mr. Coppola is familiar with practical construction activities?
No, it does not. As part of his rebuttal, he talked about his responsibility at DTE Gas on a transmission line, or what we call a midstream. That has nothing to do with distribution projects or day-to-day operation of distribution work. His other, further on, he talked about the Saginaw Bay pipeline, where he just did feasibility of the build. It doesn't really say he understands engineering of the pipeline. The other part was, as he said, additionally, as on page 12, line 11, where he talked about him being a manager of material inventory. And he further explained that warehousing and procurement at DTE Gas, I work closely with supplier pipe, control valves, flanges, meters, fittings, equipment, and 1,000 other parts and material used in the construction, repair, and maintenance of DTE Gas transmission, distribution, and storage facilities, etc. That basically tells me he just managed materials. I would not say that gives you the skill set to design and know full construction. In my past experience, when I was overseeing construction projects, my material guy doesn't really know construction day to day. And that's what he described there as his function.
So your testimony, despite these decades of experience that are detailed from pages 11 to 14 of Mr. Coppola's rebuttal testimony, that you don't think that these experiences where gave him knowledge of practical construction activities?
I'm not going to object, Your Honor, but it sounded to me like Mr. Ackus gave a very full question. If Mr. Cleaver wants to rephrase or ask in a different direction to get to that point, that's fine.
I can rephrase the question, Your Honor.
Thank you, Mr. Cleaver.
Let me ask this question. Mr. Ackus, you would agree that that involvement with a gas distribution utilities stride level distribution projects isn't the only means by which somebody can obtain knowledge of practical construction activities in the gas industry. You would agree with that, correct?
I would agree with that, but I also would say just because I witness a welder weld a pipe, that doesn't mean I could weld.
It doesn't mean you could weld, but it means that you may have knowledge of how welding works, correct?
If you have the experience to read the welding procedure, and it doesn't say that he's versed in, like in my example, with that procedure per se and process.
What about overseeing pipeline contractors?
Can you refer me where in his rebuttal where he states that, please?
Yeah, bear with me 1 second.
Okay.
If you go to, sorry for the delay, just he has a lot of experience. If you go to page 14 of his discussion, page 14 of his rebuttal testimony.
Okay.
You can see here at line 2, his responsibilities included management of the performance and profitability of the pipeline construction services business, requiring field visits to construction projects and quality reviews. In this process, I learned firsthand how pipeline construction companies operate, their construction project challenges, their bidding practices, and the bidding of construction projects, including pricing, bidding procedures, and policies, both from the contractor side and the gas utility side. You see that?
I do see that, but
Okay.
I think the key word there is profitability of the pipeline construction services is the key word there in his resume, what he's emphasizing, which he's more concerned with the profitability of the pipeline construction services. And that was his main responsibility.
Okay. You would agree that even if profitability was his primary responsibility, he could this series of responsibilities would likely give one some knowledge of practical construction activities, correct?
Your Honor, I'm going to object. I think we've spent enough time on this line of questioning. We have not challenged Mr. Coppola's qualifications as an expert in rate making. It is clear that a professional engineer has a differing opinion about the witness's engineering bona fides, shall I say. I doubt that Mr. Ackus is going to change his opinion based on further questioning.
Mr. Cleaver, are you almost done?
I'm wrapping up this line of questioning, Your Honor.
Thank you.
Is the objection overruled, Your Honor?
Overruled, but I'm hoping you're wrapping it up pretty soon.
I am, Your Honor.
All right, so can you repeat the question if you want me to answer, or do I not answer the question? I'm sorry.
That's okay, sir. The judge overruled your attorney's objection, which means that you have to answer the question. And the question was, even if profitability was Mr. Coppola's primary focus, wouldn't you agree that these activities described here, which I read, would provide one with practical construction knowledge?
I'm going to answer it this way again. It plays a role in it from observation, but even if you go through the line, is more bidding of construction projects, price and bidding procedures, that does not give him the experience to say he's an expert or have practical construction experience. That's just my opinion.
All right, I will move on. Mr. Coppola can talk about his experience when he takes the stand. Mr. Ackes, on the point, going back to your rebuttal testimony, and in fact the parts that we already went over on page 10, on this issue of the Maryland State Highway Administration, which you call and I will call SHA, you discuss with respect to a number of projects where you're responding to Mr. Coppola's adjustments. You discuss his what you frame as a lack of familiarity with SHA requirements, correct?
Yes, in general, yes, I did say that, yes.
Okay, and correct me if I'm wrong, but in many of those discussions where you mention the SHA requirements, you use this phrase, and I'm looking at it once here. We can go through all of them, or maybe we can just talk about this one as an example. But I'm on page 10, and I'm at line 11, and you say the necessity to complete a large amount of concrete base repair was not foreseen, and therefore not considered in the company's historical averages used in the estimating process, as discussed in Mr. Morrow's testimony. When you say not foreseen, do you mean because the company doesn't take those specific requirements into consideration when developing the estimates for individual STRIDE projects?
So as witness Morrow testified to earlier, we use the average cost, and some of those average costs do have paving costs included in those estimates. But I can't tell you, and no one could tell you that, hey, I have base repair or certain level of repair that's needed for each section, because we don't have x-ray vision to see exactly the pavement makeup. And if you talk to some of the people who are state highway administrative roads have been there so long, they sometimes don't even know what's there. So even if they did, even that being the case, you still won't know exactly what's on the ground per se from the paving makeup to require that much level of paving.
So, sticking to that specific project, is it your testimony that it wasn't foreseen because the company doesn't look at that and factor that into its estimate, or is it your testimony that it wasn't foreseen because it wasn't foreseeable? In other words, even if the company had attempted to factor in the specific paving requirements for the job, it still would not have caught this because it was undetectable from all the records and the job site.
So what I'm going to say, it's our estimates, which are average unit costs or average estimates when we put together an estimate, include paving costs in it. The level of paving that was required on this job would not have been included in that estimate or that average unit cost that's used to make up this project. That being said, and to your other part is, even if I had some, which it does, my estimate did include some paving, that level of detail of paving requirement wouldn't have been captured in there from historic costs.
Would this have been a job, do you know specifically about this job, if this was a job that the company physically surveyed and visited before preparing the estimate for the work?
To the best of my knowledge, this job was not surveying. Now, surveying in the sense that you send people out there to do like a land surveyor out there to survey the job. And is that in which your question is geared towards?
That's a fair request for clarification. I was using the term survey more casually. Just, is this job a job that Washington Gas personnel responsible for the estimation process or involved in the STRIDE planning would have visited in advance of, before this project ever made it to a STRIDE project list with a dollar amount associated with it?
As we discussed at the technical conference early last year, some of these projects, and this might be one, more than likely, that did not get estimated after final design or we reach 100% design. It will be using our cost estimate at the time, which more than likely it is not 100% design. And we discussed in our technical conference that the parties would allow us to update those estimates once 100% design was completed for variances or for potential variances, if any.
May I interrupt for a second? Are you speaking of the technical conferences in case 9605?
Yes, I am.
Okay, thank you. Go ahead, Mr. Cleaver.
Thank you, Your Honor. So for this project, again, just using this as an example to talk about, you said paving costs are included. When you say that, do you mean that because some jobs entail paving, that those costs are baked in on an average level, or do you mean that there's a specific paving component that's attached to this estimate?
So on our estimate, we do have, when we provide a project estimate, there is a certain paving component of those estimates, as we discussed last year.
Okay, but the company's testimony with this specific project, for example, is that the work that was required goes well beyond what would be average paving costs for a job of this scale. Is that what you're saying?
Subject to check, but I think it is. And I think I laid out the reason for that in my testimony, in my rebuttal testimony. But as Mr. Moore explained earlier as well, is that once construction is completed, that inspector has final say on the paving boundaries. In some cases, when our estimates were created, for instance, we might say, hey, we may only have to pave one lane, and then as an example, and the inspector would come out and say, hey, you have to pave curb to curb. You have to go back from intersection 1 here to intersection 2 down the street, and that's within his rights to do that.
Okay, hold up one second, Mr. Hackes. You mentioned the last couple of sentences. You said, and the paving, and then I lost you.
Yeah, so
repeat the last couple of sentences if you can remember them.
I'll try to. Let's give it a try. So, for example, in our estimate, we could estimate that we say, hey, we know we have to pave one lane because that's where we're going to do construction work. The inspector could come out after the job's done and say, hey, you need to pave curb to curb. And not only that, you have to pave curb to curb, which could be 2 lanes, could be 3 lanes for uniformity along the roadway. And you have to go, instead of 50 feet past your last cut, you have to go 100, 200 feet past your last cut on either side. So, and that we don't have a say in.
Wait, thank you. When you refer to the SHA specific requirements, is that type of post-construction conversation, is that what you're talking about?
Rephrase your question. I'm not understanding because I think
Yeah.
witness Morrow already answered that earlier.
Yeah, well, I want to, for the record, and when you speak here in your testimony about SHA specific requirements, are you speaking about those types of conversations where an inspector tells the company, for this job, you need to repave X lanes and you need to go X number feet beyond your last cut? Is that what you're talking about when you use that phrase SHA specific requirements?
Yes.
So, and just to be clear, so the SHA specific requirements wouldn't be incorporated into the paving component of the estimate that the company would provide to the commission in advance of the start of construction.
All right, so let me try to clarify this so we're all on the same page here. In our estimate, in our unit cost estimate, in which we provide to the commission, it does have a pavement component included in it. The variance is above and beyond what's included in our unit cost at the end of the day for the project.
I think I understand that. Let me try to ask the question a different way.
Okay.
When the company develops that paving component of the estimate, does that estimate incorporate SHA specific requirements?
It indirectly it does, because it's based on historical averages. So if we have faced or have encountered some form of other requirements on previously completed projects, those costs are included in the or averaged out in the unit cost that's used to estimate that project from an estimation standpoint.
So they're included in the estimate to the extent that these specific requirements are baked into the average. Is that a fair way to put it?
Or encountered previously, yes.
Could you explain that last part of your sentence, or encountered previously? What did you mean by adding that on?
So historically, if we have encountered that specific requirement, for instance, if I, in using this example, in 2018, if I had an excessive amount of paving that we did for projects, those averages will be included in the new unit cost that's applied to the new project estimate.
Okay, but beyond the, to use my phrase, scenario where the costs associated with SHA requirements get baked into the average based on what's happened in the past, there's no modifications to the historic average cost paving estimate based on one or more person at the company's knowledge of like a specific SHA requirement for this specific job based on its unique characteristics. Is that fair to say?
Yes, for this specific job, it will be like you said, yes. But moving forward, we have made some improvements through the lessons learned, where we're starting to include specific paving estimates above and beyond what's in the unit cost, based on our paving department experience based on the paving department experience and detail on that project. So let me try to clarify it without being confusing. So now, not only are we have unit costs, paving included in the unit cost, we are, from lessons learned we are and seeing that this has been an issue. Our department, engineering and paving department, are looking at these projects to see if there's any outliers that need to be reviewed or additional paving dollars placed in the estimate.
Mr. Cleaver, I'm going to interrupt for a second. Sir, when you say, I think you said going forward, or when was the change made? When did you start making those additional, use that additional expertise to change the previous average?
So the previous average is reviewed annually from an estimating standpoint from a unit cost, but from going forward from the additional review from a paving department that are looking at the projects now, will be looking at it, that just has been recently implemented over, I said, the last quarter or so. Subject to check.
Okay. Will you check and come up with a date for me, please, Mr. Dodge? I see you nodding your head.
So I scramble for my cursor. We're happy to supply that. If you'd like us to call it bench 2,
That would be great. And sir, is that just for the paving department, or is that for other departments that comprise an estimate of a project?
Currently, our engineering, my team is responsible for creating the unit cost estimate or a cost memo, and our engineers that oversee and design the projects, or project engineers, apply those units to the project. And part of that is that all that comes through our engineering department.
Thank you. Mr. Cleaver, I'm sorry for taking over. Go ahead.
Yeah, thank you, Your Honor. That was, thank you, helpful. Mr. Ackes, understanding what you just said, that new process that Her Honor asked you about, that you said in the last quarter has been developed. Just confirming, in light of that answer, I think it's fair to say that process didn't happen for the projects that are at issue in this case, correct?
I would agree with that.
Thank you.
For these projects.
Okay, thank you. Mr. Ackes, just one more brief line of questioning, and I think we've largely covered it. You may have already given the answer. Your Honor, I circulated today an additional exhibit. I just came up as I was preparing this morning. I did send it to the parties, and Your Honor, I don't know if everyone's gotten it. I can share my screen if not. I marked it as OPC Exhibit 16. It's a short excerpt from a hearing transcript from the company's Stride 2 case. Well, let me ask first. Your Honor, did you receive that?
I did. I want to ask the other parties, does anyone have an objection to Mr. Cleaver using that exhibit at this time?
no objection, Your Honor.
Okay, go ahead, Mr. Cleaver. I just wanted to make sure everyone received it.
Thank you, Your Honor. Mr. Ackes, did you have before you, did your counsel provide to you what was marked as OPC Exhibit 16?
I think I have it. It's 4 pages PDF.
That's right.
Okay, yes.
And we've already established earlier that case number 9486 was the company's Stride 2 case, as it's called, where the commission reviewed the company's second 5-year Stride plan, correct?
Can you repeat your question? I'm sorry.
Sure. It was, just for the record, this is a, let me try it this way. I withdraw my question to Mr. Ackes. I'll just state for the record. OPC Exhibit 16 is an excerpt from a transcript from Commission Case Number 9486. It's the evidentiary hearings. It's from Thursday, September 10th, 2018. And the exhibit consists of a cover page for the transcript of the hearing, and then 3 pages of the actual transcript from pages 192 to 194. And it's the entirety of Mr. Dodge's redirect examination of a Washington Gas witness named Walsh, W-A-L-S-H-E. Mr. Ackes, you were a witness in case 9486, correct?
Yes, I was.
And do you remember the Washington Gas witness, Mr. Walsh?
Yes, I do remember Mr. Walsh.
And Mr. Walsh was brought in as an outside witness who prepared a study of the history of the company's STRIDE program and the regulatory history of how the information had been reviewed, and also an analysis of the company's estimation procedures. Is that a fair characterization?
Yes, I would say that.
Yeah. And I just want to direct your attention to the bottom of page 193, line 17. And there, Mr. Dodge of Washington Gas asked Mr. Walsh, and did you conclude that there's a systemic issue with Washington Gas's cost estimation processes in light of Figure 11? And Mr. Walsh says, not in light of Figure 11, but we did conclude that Washington Gas underestimated escalation and underestimated the impact of paving. So those two I would call systemic. So I wanted to ask you about this today, and you might have already given the answer. I wanted to ask you what the company has done to address the systemic problems, in the words of its witness, with the estimating the impact of paving. Is the answer to that question the new process that has developed in the last quarter that you described to Her Honor?
I think there's two parts of that we use to address that. One is that we evaluate the paving annually, and we have increased the unit cost, or the percentage that goes towards the project cost for paving. We looked at that. When that's done, we evaluate that through lessons learned and through variance analysis, just as similar as Mr. Walsh noted there in the testimony. And based on that, we say, well, that is not corrective through continuous process improvement. Now we're throwing another layer on top of that, which is what I discussed earlier.
Thank you, Mr. Ackes.
Thank you.
Your Honor, I don't have any further questions at this time of Mr. Ackes. I would ask that OPC Exhibit 16 be admitted at this time.
Any objection? OPC Exhibit 16 is marked and admitted at this time.
Thank
Mr.
you.
Wilson, do you have cross? I think I can read your lips and see you saying no, you have cross, but you're muted.
Don't cross, Your Honor.
Okay, thank you. Mr. Dodge, do you have redirect?
I do, and a bit of indulgence, if you please, Your Honor. I'm grateful that Mr. Cleaver covered so many topics, important topics, and went in depth. I think he may have, in follow-up questioning, limited some of my redirect, but if I could just have a moment to look at my notes.
Yes, sir.
Mr. Ackes, can you hear me okay?
Loud and clear, Mr. Dodge.
Just a few follow-up questions from your discussion with Mr. Cleaver. Do you recall a discussion with Mr. Cleaver about budgeting for a 5-year plan versus budgeting for independent projects?
Yes, I do.
Are budgets for 5-year plans and individual projects both reliant on estimated costs?
Yes, they are.
We also had a brief discussion with Mr. Cleaver about your participation in administrative hearings, and in particular, commission discussions or party discussions about reserving prudency reviews of STRIDE projects to the company's rate cases. Do you recall that discussion?
Yes, I do.
Earlier in your rejoinder testimony, I think I had asked, or I tried to ask, whether any party in STRIDE 2, that is case 9486, questioned variance explanations, not prudency explanations. Is that correct?
That is correct.
You had a interesting to me discussion with Mr. Cleaver about paving requirements and how local jurisdictions sometimes extend paving requirements well beyond what the company anticipated, say, in an intersection or between two intersections. Do you recall that discussion?
Yes, I do.
If you know, Mr. Ackus, and only if you know, in your experience, do local jurisdictions require additional unforeseen paving or renovations as a part of a venture to repair their roads?
Oh, definitely yes.
Last question. You had a lengthy conversation with Mr. Cleaver about SHA specific requirements. Is that correct?
Yes.
Do you agree with Mr. Morrow in that light that these requirements also pertain to the Maryland Department of Transportation and the Montgomery County Department of Transportation?
Yes, I do.
That's all I have, Your Honor. Thank you.
Thank you, Mr. Dodge. The SHA requirements, is that something that you know going into, are the requirements those that you know going into a project, or do you also, are you made aware of other requirements as inspections occur and as the project proceeds?
So there are standard requirements, but if you read the fine print, it says also as directed by inspector. So if the inspector come out there, you might plan for one thing, and the inspector come out here and say, no, you need to do this, you have to do it.
So in your testimony, when you referred to SHA requirements, were you referring to the ones known as you're estimating the project, or were you referring to those in addition to the ones that you find out as the project occurs?
I was referring to the one in addition as the project occurs.
Okay. How is WGL's process of estimation different for the 5-year estimate versus a project-specific estimate?
So our 5-year estimate takes take a holistic approach to the plan. So we say, for instance, we know we have X amount of miles of main we want to replace in the program that goes over year. And I'm just speaking high level, Your Honor. And then when you go annually, based on the mix of work, your estimate's going to change. So once you get more detail about the size, the project, the size main, the length of service, you get more the definition around the project scopes. And so that gives you a more project level estimate, Your Honor.
All right, I want to be a little more specific with that question and response. So
Okay.
Can you, I'm not sure how to make it easy for you. Can you either give me an example, or can you give me what the different, if there are different inputs, or can you just be more specific with that response, please?
Yeah, so from a plan perspective, we do our plan in 5-year increments. So when we look, we say based on, first we go with our distribution integrity management, we see what facilities need to be replaced, what programs to develop, and then we say, okay, we have a flat average across the board that we use to estimate service and main to be installed. And then we say we want to, for each programs, we come up with, like our service only program, we have a cost per service. And then we have a overall average cost per foot, and we put that in there and then come up with the cost annually for that year in a 5-year plan. So they're still historic, but it's high level average. And so those averages, and then annually we'll do an inflation cost annually to get out to the 5 year. So in the case of Stride, we'll have the annual cost inflated year over year to a certain dollar amount. Then from a project perspective, and let me give it specifically. So for like project 1, 2, 3, 4, 5, BCA 1, 2, 3, 4, 5. So we'll say we're going to install 1,000 feet of main and 5 services. From a project estimate standpoint, the level where we are, it might not be fully designed by the time it goes on a project list. Most likely it's not. So say we're installing 2-inch plastic. We have a unit cost that goes to 2-inch plastic. And so we will apply that cost that based on our cost memo to that 2-inch plastic. Then we'll look at the services and see, okay, what is the services like? And we'll put that cost, whether it's a tier 1, which we talked about before in my testimony, and that's service replacement under 2 inches, less than 140 feet. So we have a cost breakout for that. And it varies. So you have basically 4 tiers of service. So we look and provide costs for each one of those services. That's then submitted on the list. Once that's submitted for the list on a project, we estimate each project like that to add up to our total approved expenditures for the year. That being said, it's approved. We go through 100% design. And that's where some of the variances occur. And in our technical conference, as we talked about earlier, now we have the opportunity to update those as final designs are completed before construction to complete this variance analysis. The estimate is a management tool, Your Honor, and that's what we use that. We have variance meeting that we look at those variances as they're coming in and see what those drivers are and try to address those if we can mitigate those immediately, or in the future year, like the next year's project list, we address those then.
Did I understand you correctly to say for any given project, would there be as many as 3 or more estimates? 1 at the 5-year plan, 1 for the next year, and 1 once the plan is, once the project is detailed?
Yes, Your Honor. I think if I understand your question, yes. So there's at the 5-year level, we have the 5-year level, then we have an annual expenditure that we tried that includes units that's associated with those plan years, and then at a project level.
And then Mr. Dodge asked you if the estimates at the project level and the estimates at the 5-year level, I think, Mr. Dodge, are both based on, if those are both based on estimates, I think, was the question. So, but my question is, are those estimates the same, calculated the same way?
They are the best, let me see the best way to say it. They are all using historical averages put together, but based on a project, at a project level, we go to more details as we talked about based on the size of the main, length of services, because at the high level, at a plan level, you don't know the size of the main per se, because project mix and service mix change annually. But it's still
safe to say
the
that
same methodology.
So it's safe to say that a historical average, once a project is developed, they're apples and oranges, because they're comparing different historical averages for different level specific level forms and functions. Is that correct? So a historical average for a historical average for the 5-year plan for a project that's gonna, replace services on a specific line would use different factors, different historical averages than that specific project plan that might happen 3 years later, once it's decided what size pipe to use.
That is
Is that
correct.
correct?
Yes, that is correct.
Okay. Give me just a moment.
Mhm.
I don't have any further questions. Mr. Dodge, do you have any questions based off of my questions?
No, Your Honor, thank you. We're done.
Okay. Thank you, Mr. Akas, for your appearance today.
Thank you.
Okay, we're at the point where it's 1:46. Folks may be getting hungry for lunch, but I think we should discuss what's going to happen with the rest of today and should the witnesses go further than today. My inclination is to take a short lunch break, maybe half an hour, and then to try to push through as many witnesses as we can today. I've checked and there are no other hearings on Monday or Tuesday at the commission, and this platform is available for the public utility law judges. I haven't checked with Mr. Court Reporter to see if they're available on Monday or Tuesday, and I would question the parties to see if you all are available and your witnesses are available on Monday or Tuesday.
We are available, Your Honor.
Yeah, Your Honor, OPC had known of the 11th as a potential third day, so we're all available as counsel. I haven't talked to the witnesses about that. I think most of our conversations were about Thursday and Friday. So let me, if I could, with Your Honor's indulgence, ask our three witnesses about their availability Monday, and we could let the parties know as soon as we hear from them.
Okay, that'd be great. Maybe you can use the lunch half hour to do that. Ms. Francis, I see you raising your hand.
Yes, Your Honor. AOPA attorney is available on Monday. Our witnesses are waived in, or so they won't be, as long as they don't have to take the stand, because I haven't checked with him to see if they're available, but I am available Monday.
GSA Montgomery County, you don't have witness issues, but how are you for availability?
I'm available.
I'm available on Monday as well.
Mr. Court Reporter, Doug, are you available on Monday?
I will make myself available.
Okay, thank you. So the plan is we're gonna, unless anybody has an objection, we're gonna take a half an hour lunch break now, and then we'll proceed with the next witness. And we'll go till about 6 tonight, and then we'll pick up again on Monday.
That's fine with AOPA, Your Honor.
Okay, great. Okay, folks, have a nice lunch break. We'll go off the record.
Off the record.
see Mr. Wilson, Ms. Brennan. Don't see anyone from OPC or the company. There we go. OPC's in. There we go. Mr. Court Reporter, can we go on the record, please?
We're on the record, Your Honor. Thank you.
Thank you. Mr. Dodge, do you have another witness?
Indeed we do, Your Honor. Washington Gas calls Matthew Esmacher to the stand.
Present.
I see you, Mr. Esmacher. Can you raise your right hand, please? Do you swear or affirm that the testimony you're about to give is the truth?
I do.
Thank you. Can you spell your last name for the court reporter, please?
Sure, it's E as in Edward, S as in Sam, M as in Mary, A-C-H-E-R.
Okay, great. Ms. Rodriguez on the call, I'm muting you, if that's okay. If you are unmuted for a reason, please let me know. And it looks like we're good to go. Mr. Dodge, your witness.
Thank you. First, I apologize. A colleague walked by my office and I did googly waves to her. She's a very nice person, so my apologies again. Good afternoon, Mr. Esmacher. Can you hear me okay?
I can, Mr. Dodge. Can you hear me?
I can. Thank you, sir. By whom are you employed?
Washington Gas Light Company.
And how long have you worked for the company?
This June, it'll be 33 years.
Congratulations.
Thank you.
What is your current position with the company?
I am the Director of Project Engineering and Management.
Are you the same Matthew Esmacher who caused to be filed in this case on December 8th, 2020 rebuttal testimony?
I am.
Am I correct that your rebuttal testimony consists of 32 pages of narrative questions and answers?
I believe it was 20 pages.
All right, we'll go with 20. Thank you for that correction.
Sure.
Did your rebuttal testimony also include 5 rebuttal exhibits?
It did.
Thank you. Your Honor, I believe we are now up to 21, and I would ask that Mr. Esmacher's testimony be marked as WGL 21.
WGL 21 is marked. Are there any objections to its admission? I know Mr. Dodge hasn't moved for that yet, but it is admitted at this time.
Thank you, Your Honor. Mr. Esmacher, was your rebuttal testimony prepared by you or under your direct supervision or control?
Yes, it was.
At this point, do you have any corrections or other changes to make to your rebuttal testimony or the accompanying exhibits?
I do have corrections to make. In my rebuttal testimony regarding the Strip 15 pressure test project, it's on my rebuttal testimony, page 14, lines 3 through 5. I stated that the inspection digs produced evidence of a weld over sleeve and damaged and deteriorated piping in 3 separate sections. That's incorrect. Upon further investigation and a site visit with my product engineer, I would like to change that statement to read, the inspection digs produce evidence of a weld over sleeve and damaged and deteriorated piping in a total of 2 separate segments. The identified pipe segments were 3 initially, it's actually 2. And similarly—
I'm sorry, can you, yes, look up and talk into the computer, please.
Yep, sure. What part didn't you get, Doug?
Perhaps it would be safe if you reread the correction.
The correction should read, upon, the inspection digs produced evidence of a weld over sleeve and damaged and deteriorated piping in a total of 2 separate segments. Okay.
Sorry, I hate to interrupt. I am not getting it. You need to get closer to the microphone on the computer and speak directly and loudly into it. I don't know what's going on, but I was getting some kind of feedback or something. I don't know.
The witness just said the inspection digs produced evidence of a weld over sleeve and damaged and deteriorated piping in a total of 2 separate segments.
Correct.
Thank you.
Go ahead, Mr. Dodge and Mr. Esmacher.
One more correction, Your Honor. On page 14, line 7, the word 3 likewise should also be changed to 2.
Thank you, Mr. Esmacher. Do you have any changes to your rebuttal exhibits?
I do not.
If I asked you the questions contained in your rebuttal testimony here today, would your answers be the same?
They would.
Do you adopt this testimony as your own in this case?
I do.
Your Honor, we do have a brief live rejoinder for Mr. Esmacher, if I may.
Hang on 1 second. I'm gonna make the changes, striking 3 and putting it to 2 on both lines 6 and 7 of your rebuttal testimony at page 14. Is that correct?
Well, let me check, Your Honor. Yes, line 6 as well.
Okay. Mr. Dodge, go ahead with your rejoinder.
Thank you, Your Honor. When you're ready, Mr. Esmacher.
I'm ready.
Am I to understand that OPC witness Coppola raised criticism surrounding the Bull Run Access Road project?
Yes, you're correct.
Is one of his claims that an on-site inspection of that area would have provided valuable information about wet areas and the presence of an underground spring, a water spring?
That is what he did assert, yes.
Can you address that claim, please?
Yes. His statement is sort of correct and not correct. An investigative site visit analyzing the surface conditions of a future construction site is part of due diligence in the planning phase of a project, but it does not guarantee what the conditions will be below the surface when construction takes place. A pre-construction investigative analysis can only reduce the risk of unknown desirable subsurface conditions that would be discovered during construction. With respect to the project in question, such an investigation was performed, but yielded no indications of problematic subsurface conditions.
Thank you. Is it true, as OPC witness Coppola claims, that the company did not perform an investigative site visit that would have detected that underground spring?
Hang on a second, Mr. Dodge. I think you're going to have to repeat that question.
Mr. Matthew, when he looks down, I lose him. He has to look, even though he's reading, he has to sort of look right into the computer. And I know it's strange, but I didn't pick up what he said. And then Dodge came in. I've tried to, please help me out.
Mr. Esmacher, can you repeat your answer to my question?
Hang on just 1 second. Mr. Esmacher, when you repeat the answer to your question, can you hold your paper up so you're looking at it?
Yeah, it is in a binder. Okay, I will repeat the answer.
Thank you.
The answer to the question is Mr. Coppola correct in his assertion that an on-site inspection of the site prior to construction would have yielded a presence of underground water? The answer is yes and no. An investigative site visit analyzing the surface conditions of a future construction site is part of due diligence in the planning phase, but does not guarantee what the conditions will be below the surface when construction takes place. A pre-construction investigative analysis can only reduce the risk of unknown desirable subsurface conditions that could be discovered during construction. With respect to the project in question, such an investigation was performed, but yielded no indications of problematic subsurface conditions.
Thank you. Before we proceed to my last question, I want to make sure that the court reporter heard and recorded Mr. Esmacher's answer.
I did, and thank you very much. That helped a lot. I appreciate it. I'm sorry for interruptions.
You're welcome. I'm sorry I'm not talking loud enough. I'll try to talk louder, then.
Mr. Esmacher, I'm going to jump to a final question.
Sure.
You're an engineer, so you may have to pick up your binder again. I trust you to do that correctly. There's been a significant amount of criticism leveled by OPC witness Coppola regarding the company's execution of the design phase of project development. Is that correct?
That's correct.
Could you opine on whether the purpose of the design phase of a project is to develop a qualified cost estimate for that project?
Sure. The answer is no. The design evaluates all aspects of a project, its objectives, the process criteria, the functional requirements, the major equipment required, the cost estimate, and the schedule to determine the best avenue to advance forward in order to obtain the project's business case objective. The cost estimate is just one of the design aspects. It's not the goal. Per PMI, that's the Project Management Institute, product design is a methodology that identifies, quantifies, and characterizes the significant effort of coordination that is present in complex projects.
Thank you, Mr. Esmacher. That's all we have on rejoinder, Your Honor, and the witness is available for cross.
I believe that AOPA, GSA, and Montgomery County have no cross for this witness, so we'll move to OPC. Mr. Cleaver.
Thank you, Your Honor. Good afternoon, Mr. Esmacher. My name is Joe Cleaver from the Office of People's Counsel. How are you?
I'm doing well. Good afternoon, Mr. Cleaver.
Hi. I don't think we've met, but I think that you may have been in a working group with Mr. Burkowski from the staff that we were both in.
I probably have seen you around circles, yes.
That's right. That's right. All right. Well,
nice presence, yeah.
Yeah, nice to see you. If I could ask you to turn to your rebuttal testimony at page 3.
Okay.
Yeah, just a point of clarification here. At line 13, you say OPC witness Coppola states that cost overruns, which are more correctly termed variances, are the result of imprudence. Do you see that?
I did.
You would agree that Mr. Coppola doesn't automatically characterize any variance, as you term it, or overrun, any amount above an estimate. He doesn't automatically say that's imprudent, correct?
I would say that the main driver in what he says the cost estimates are due to is imprudence. Not all of it, but so you're correct in that, but the main driver of the cost variances is due to imprudence.
For specific projects. In other words, you would agree that you would agree that Mr. Coppola doesn't make an allegation in this case that every single project where the company went over its cost estimate was imprudent. You would agree with that, correct?
I don't know that I can do that, Joe. I only know about the 2 projects that were under my sphere of influence that Mr. Coppola addressed. For my 2 projects, yeah, okay.
That's fair enough. I understand that limitation. Thank you. If I could ask you to turn down to page 6 of your rebuttal testimony.
Okay.
And there you say at line 21, the full project scope, the description of increases in scope, and why these increases in scope resulted in increases in cost are all essential to conduct a prudency review. Did I read that correctly?
Yeah, that's correct.
And then the sentence immediately before that, you say, this is line 19, Mr. Coppola did not request, nor did the company provide detailed reasons for why the scope increases resulted in cost increases. Did I read that correctly?
That's correct.
Thank you. And if I could now ask you to scroll down to page 7, and specifically I want to ask you about the Bull Run Access Road project.
Sure.
Before I get to the question I plan to ask, let me ask you about something that you talked to Mr. Dodge about. You told Mr. Dodge that a pre-construction investigative site visit had been made by the company. Do you remember that?
I do.
And your testimony to Mr. Dodge just a couple minutes ago was that that visit didn't reveal any signs of the water issues that ultimately resulted. Do you remember that?
I did.
Okay. Can you describe for us what exactly that site visit entailed?
I can. As I stated in my rebuttal, page 18, lines 13 through 20, the ground was dry at grade prior to construction and gave no indication that the spring that existed below. 1 year prior to construction and 3 months before the development of the cost estimate, Washington Gas hired a third-party geotechnical engineering firm to conduct a geotechnical survey along the entire length of the roadway. A geotechnical report is the best engineering method available to determine ground conditions and constructability of a project prior to going to construction. The geotechnical report provided no evidence of an underground water spring. The company's most senior engineer, who's a licensed geotechnical professional engineer, reviewed the geotechnical report and concluded that the report, and I'm quoting here, indicated a complete lack of groundwater. So it's reasonable, and I'm continuing the quote, so it is reasonable to state any water encountered during construction can be classified as unseen, end quote. That's the analysis. We did a thorough geotechnical review of the road.
Okay. Do you know whether that report was produced in this case?
I do not believe that was included as part of my testimony.
Okay. Sticking with the Bull Run Access Project, there was just one thing I saw that I wanted to ask you about it in your discussion.
Sure.
Specifically, I want to ask you on page 9.
Page 9 of my rebuttal, Mr. Cleaver?
Yes, rebuttal, yes.
I'm sorry, my rebuttal?
Yeah, it's okay. It gets confusing, all these different
It does.
versions of testimony.
I learned all kinds of new words during this.
Yes. Sometimes I'm not sure if they even, one time the commission allowed someone to do response to rejoinder and they were calling it Sir Rejoinder. Never heard of it before, but learned something new. On page 9 of your rebuttal testimony,
yes.
You're talking about access limitations that were imposed by this company Williams that owned the property, correct?
That's correct.
Okay, and on line 10 here, you say this created additional daily startup and shutdown time for the project and created missed opportunity costs for the contractor who increased costs for the project to compensate. So I wanted to ask you about that. If these contracts are bid out, as I understand, Mr. Akis and Mr. Morrow to have explained,
yes,
based on historic averages.
No. That is. Can I stop you there, Mr. Cleaver?
Yeah, sure.
These projects are not bid on historical averages. These projects are bid on a specific project basis.
I see. So, and that's a distinction that I think one of your witnesses made earlier today. Is that right?
Mr. Morrow made that distinction. Yeah. That's correct.
Yeah. Okay. Thank you. That's helpful. So let me ask you this: is it if you know, and not asking you for legal opinion, is this a standard provision in the contracts when you bid these costs out that if there's limitations imposed by some third party and the contractor therefore can't work as much, that the opportunity costs are somehow the responsibility of Washington Gas? Are you able to speak to that at all?
Perhaps. The generally in these projects, and I don't know specifically for this exact project, but the statement of work will indicate, or the construction specification will indicate what hours the contractor can work. Does that answer your question, Mr. Cleaver? And
Well,
then if you change those hours, there's only so I'm not sure I can answer your question. Can you rephrase it for me?
sure. Yeah, happy to. On a project such as this, where you say here at lines 10 to 12 that the missed opportunity costs to the contractor, which were one of the results of the limitations on when the work could be done, you say that the contractor in response increased costs for the project to compensate. Let me ask you this foundational question first. Am I correct to understand that to mean that the cost that the contractor ultimately billed to Washington Gas was increased because of the contractor's missed opportunity cost?
Yes, he when we asked him to perform work that was outside of the original hours that he was told he could work, it extended his days, the number of days that he had to show up on the project site. So that was evidence that costs should be increased as a result. The hours we told him he could work, he could not work for the entire duration of the project.
So is this was the contract renegotiated and for a different amount, or is there some kind of mechanism? If you know, I don't want you to get into legal issues, but just if you know, I'm just trying to understand how this works. In that scenario, was the contract renegotiated, or is there some kind of mechanism that dictates when or how the additional funds will be billed to the company based on the contractor's missed opportunity costs?
I'm not sure in this project, if that was done ahead of time for this project. In this project, the extra work did have an additional, or the additional time that was required. He did create an additional quote for that extra work that was reviewed prior to doing it, and that was accepted, and it allowed him to do it for the extra work that was incurred.
I'm sorry, I'm going to interrupt. Mr. Esmacher, when you say the additional, he created a new bill for the additional work, do you mean the additional days that he was required to show up to complete the project?
Yes, I'm sorry, Your Honor. The additional days that he was required to show up.
Okay, thank you.
Thank you, Judge Grace. So, thank you for that, Mr. Esmacher. Just one more, maybe the famous one question. One more or two more questions about following up on the geotechnical survey of the property of the, again, sticking to this Bull Run access project.
Sure.
I mean, let me ask you this. I mean, do you know if the presence of water didn't show up in the geotechnical report, but then it was there?
Yes.
Do you have an explanation? Was there a material change in the surface conditions, or
no?
What's the explanation for that? I mean, why didn't the report capture that?
That's an excellent question, Joe. I'm sorry, Mr. Cleaver. So basically, what's occurred here is that the soil there has a clay component to it. And the clay acts as sort of like pottery, if you will. And it'll hold below it. Pottery is impermeable. And pottery will hold water very well, and it will mask waters below the surface as occurring that it'll mask water that's below the surface from occurring above the surface because it's being held in place by the clay. Also, it is important to note in the geotechnical report, it does have a note there that states if the conditions, environmental conditions change, it noted that there was no groundwater located within the report. It's very clear it did that. However, it also noted that if the conditions were to change, if the environmental conditions were to change, that could change. So in 2018, that was the rainiest record we ever had in history in this area. And that's when this construction was taking place. And the excessive rain produced a lot more water than before. So it changed the conditions from when they conducted the geotechnical report to when we actually went to construction. The geotechnical report was conducted a year prior to when we actually went to construction. So the environmental conditions changed drastically from the year it was conducted in 2017 to the year the construction actually took place in 2018.
Okay, and thank you for that explanation.
Sure.
Just let me ask you just one more thing about that. Based on your understanding of the geotechnical analysis, I mean, how deep down does the analysis go in terms of examining for water below the surface?
The requirement for a road to dig is every 500 feet, you need to have at least 2 boring samples done for your geotech report. This was a 750-foot long road, and it had 4, so we exceeded the amount that was required. The depth of those, I'm not certain how deep they go in their soil borings. I would have to check with Czech. I would say they could probably lead 2 feet deep. And since the road was approximately had a 16-foot base, it's most likely they went down 2 feet. I'm not 100% sure how far they went down in their soil borings, but they do go below the surface. Correct. We had 4 soil borings conducted for the geotechnical survey.
Okay. Your Honor, if I could have a moment here, Mr. Esmacher, I think I'm nearing the end. Your Honor, may I have your indulgence for just a moment?
Yes, sir.
And if I could say in that moment, I will have no questions, Your Honor.
Great use of time, Mr. Wilson.
I don't have any further questions. Mr. Esmacher, nice to speak to you. Thank you for your time. Thank you, Your Honor.
Nice to speak with you, Mr. Cleaver. You're welcome.
Mr. Dodge, do you have any redirect?
I have no redirect, but I will note for the record, it's nice to hear the word boring in a rate case hearing that doesn't have to do with the other content of the rate case.
I think Mr. Dodge is starting to lose it on the second day. Thank you, Mr. Esmacher. I appreciate your appearance. I don't have any questions for you. And
thank you, Your Honor.
Thank you. WGL can call its next witness.
Thank you. Our next witness is Stephen J. Price.
Good afternoon.
Good afternoon, Mr. Price. Can you raise your right hand, please?
Yes, Your Honor.
Do you swear or affirm that the testimony you're about to give is the truth?
I do.
Thank you. Your witness, Mr. Dodge.
Thank you. Mr. Price, can you hear me okay?
I can, Mr. Dodge. Could I just check with the court reporter that he can hear me okay? I've had some issues with WebEx in the past.
I'll stay on top of it. Don't worry. Just speak as loud as you can and get close to the computer.
Yes, sir.
Mr. Price is closing in on the computer, so here we go. Mr. Price, by whom are you employed, sir?
Washington Gas.
And how long have you been with the company?
23 years.
What is your current position with the company?
I'm the assistant vice president for EHS, the utilities division.
Are you the same Stephen Price who caused to be filed in this case on December 8th of calendar year 2020 rebuttal testimony?
Yes, I am.
Am I correct that your rebuttal testimony consists of 11 pages of narrative questions and answers?
Yes, it does.
Am I also correct, sir, that there are no exhibits appended to your rebuttal testimony?
That's correct.
Does your rebuttal testimony include any confidential information?
No, it does not.
Your Honor, I believe we are now up to 22, and I would ask that Mr. Price's rebuttal testimony be marked as WGL 22.
WGL 22 is marked. Are there any objections to its admission? Without objection, WGL Exhibit 22 is admitted.
Thank you, Your Honor. Mr. Price, was your rebuttal testimony prepared by you or under your direct supervision or control?
Yes, it was.
At this point, do you have any corrections or other changes to make to your rebuttal testimony?
No, I don't.
If, sir, I asked you the questions contained in your pre-filed rebuttal today, would your answers be the same?
Yes, they would.
Do you adopt this testimony as your own in this case?
I do.
Your Honor, we have no rejoinder for Mr. Price, so he is available for cross.
Ms. Francis.
Good afternoon, Mr. Price.
Good afternoon, Ms. Francis.
I'm going to ask you to start your cross by looking at page 8 of your rebuttal testimony. And I direct your attention to the discussion that begins on line 16. Tell me when you're there.
I am there.
Okay, now based on your testimony at page 8, lines 17 through 19, is it your position that Washington Gas is currently taking, quote, prudent and reasonable measures to both manage and modernize its aging system in Maryland, end quote?
Yes, it is.
Now, am I correct that you take that position despite the increases in hazardous leaks on the company's Maryland distribution system that have been documented in this proceeding?
Yes, I take that position with the knowledge of the leak trend.
Is there any level of increases in hazardous leaks on the company's Maryland distribution system that you would not find to be reflective of reasonable and prudent actions by the company?
I really wouldn't speculate on that point, Ms. Francis. I can tell you that we're aware of the leak trend. We have testified about it transparently before the commission. We are taking measures through our STRIDE program to reverse that leak trend, which we expect will occur. And in the meantime, we are managing a safe and reliable system every single day.
So is it your position, Mr. Price, that as long as this company is pursuing its STRIDE and doing what's necessary to pursue STRIDE as outlined in commission orders, how high leak trends are will never be a reflection of unreasonable or imprudent actions by the commission? Is that correct?
Mr. Price, can you speak up a little bit because I'm having trouble hearing you?
Yes, I will. Yes, I will.
No, not you, Ms. Francis. Mr. Price.
Oh, sorry.
I will
Mr.
try
Price,
and
just speak up a little bit for me, please.
Yes, sir. So I guess I understand your question again to be some sort of future event that I wouldn't speculate on, Ms. Francis. I would say that the current state of our system and the actions that we are taking, both proactively and to maintain the system, as well as to condition the system on those issues that are generating leaks, lead us to the conclusion that we have and do run a safe and reliable system. As far as future developments, we will address any future developments as they come.
Now, starting at line 3 on page 9 of your rebuttal testimony, you discuss the treatment of gas costs and witness Bruce Oliver's recommendation that the commission limit the level of unaccounted for gas for which Washington Gas is provided recovery. Do you see that?
Which It's page 9, but which
Sorry,
line?
page 9, starting at line 3.
Okay, I see that testimony.
Okay. Just by way of background, let me just switch to your background for a second. When I read your qualifications, you're an attorney, correct?
You're not going to hold that against me, are you, Miss Francis?
Definitely yes. But you are an attorney, correct?
Yes, I am.
Okay. And you're not an engineer,
No, I'm not.
and you really don't have any rate making experience. Is that correct?
I'm not a rate regulatory attorney.
And you don't have a financial background, correct?
That's correct.
Okay. Am I correct that your response, getting back to page 9, that your response on page 9 in addressing Mr. Bruce Oliver, you suggest that unaccounted for gas is a gas cost that is handled in separate purchase gas adjustment charge proceedings. Is that correct?
That is correct.
What has been your level of participation in purchase gas cost proceedings before this commission?
I haven't participated in such proceedings, and I think I sort of prefaced that statement that I'm not the expert in rate making matters, but I think I stated the company's position here accurately, and that's what I sought to do.
And you have never testified in a purchase gas proceeding, correct? A gas cost proceeding, correct?
That's correct.
Would you agree that usage for all customers is subject to an adjustment for lost and unaccounted for gas, regardless of whether they purchase their gas supplies from the company or from a competitive gas suppliers?
I don't know the answer to that question, Ms. Francis. I do know that lost and unaccounted for gas is the subject of an adjustment, but the granularity of your question, I don't know that.
I'm sorry, can you please speak up? I'm having trouble hearing you, Mr. Price.
Yes, sir.
He finished his answer with, but the granularity of that, I don't know.
I got it. It's just that he's so low, it's really hard to record.
Your Honor, could I just take a shot at removing these earphones and see if the computer speaker itself might enhance that?
Absolutely, Mr. Price.
Your Honor, I don't know about anybody else, but I don't have a hard time hearing Mr. Price, but I do have a hard time hearing the court reporter. His voice comes through as muffled to me.
Yeah, I was having the same problem earlier, but let's just see if Mr. Price, let's see if this works now. Go ahead and Ms. Francis, and ask your next question.
Okay. Mr. Price, can you tell me how is unaccounted for gas reflected in delivery service customer bills?
I don't know, Ms. Francis.
Now, at page 9 of your rebuttal, this time let's look at lines 14 through 15. And you state on those lines, I'm going to quote, "There are many causes contributing to unaccounted for gas cost, of which leaks are only one," end quote. Do you see that?
Yes, I do.
Am I correct that Washington Gas has made no quantifications that various factors have to the company's overall lost and unaccounted for gas percentage?
Do I understand your question to mean quantifications as to each of those factors that contribute to the lost and unaccounted for gas? Is that correct?
That's correct.
I'm not aware of specific quantifications by factor, Ms. Francis.
Yeah. Am I correct that the cost for providing, excuse me, scratch that. Am I correct that costs for responding to system leaks are a very prominent element of the O&M costs that are included in the company's base rate revenue requirement in this proceeding?
You are correct.
Would you agree that greater numbers of distribution system leaks create greater opportunities for increases in the company's unaccounted for gas percentage?
I think I would agree with that I think I would agree with that, yes.
Mr. Price, would you agree that the accuracy of meters may influence the company's levels of unaccounted for gas reported by the company?
That is an accepted factor that contributes to lost and unaccounted for gas.
Is it your understanding that costs for checking and maintaining meters are included in the company's base rate revenue requirements in this case?
Yes.
Can the company's level of unaccounted for gas be influenced by the company's leak detection efforts?
I'm not sure I understand that question, so.
Let me try it again. Is the level of unaccounted for gas that Washington Gas experiences, is that affected by any of the leak detection efforts on the part of the company?
I haven't drawn such a relationship, but I may not be understanding your question.
The company undertakes leak detection efforts, correct?
Correct.
How good a job they do on that, or how much effort they put into it, that does affect the level of unaccounted for gas, does it not?
No, at least based on the way you've asked that question, I wouldn't agree with that. Our leak detection is a part of our entire leak management program. You identify leaks proactively through it. We also identify leaks in other ways, and the totality of that identification prompts resources to be directed to any leak that is identified, investigated, and responded to. So I hope that's giving you the big picture context of where leak detection, at least proactive leak detection, falls into that process.
I think I heard a contradiction in what you're saying, so let me try it again. You're saying that the entire picture of leak detection, not just unaccounted for gas efforts, affect the company overall. Is that what you're saying? That it isn't only one factor, which is unaccounted for gas?
I'm sorry, I just did not understand that question.
Okay. When the company undertakes leak detection efforts that we agreed they did, correct?
We do.
Okay. Now, why do you do that? Why does the company do that?
We do that as an element of proactively identifying any leaks on our system.
Okay. But when you proactively identify leaks on your system, doesn't that influence the level of unaccounted for gas on your system?
No, I would say it's simply an identification of a leak, which goes back to your original question, which I think I agreed with, that if leaks are increasing, there is some impact on unaccounted for gas, and the survey questions are simply a method by which we identify those leaks. I would suggest that by proactively identifying such leaks, we are actually mitigating any impact that a leak would otherwise have on lost and unaccounted for gas, because we are responding to then a known leak.
I understand that answer. And I think what that answer shows is, in your attempting to mitigate through identification the leaks, it ultimately mitigates the effect of unaccounted for gas. Isn't that what you're saying?
Correct.
Okay. Are costs for leak detection activities included in the company's base rate revenue requirements in this proceeding?
Yes.
Does the company's base rate revenue requirement in this case include costs for investigating suspected cases of theft service?
I would assume so. I don't have specific knowledge of that, but I would assume so.
Am I correct that Washington Gas does not compute unaccounted for gas percentages by jurisdiction, but instead reports a single uniform unaccounted for gas percentage for all of its retail service jurisdictions?
I don't know the answer to that question, Ms. Francis.
I'm going to ask you to please reference what has been previously identified, Your Honor, as AOBA Exhibit 13, which is copies of the company's response to AOBA Data Request 9-6 and 9-7, informal case number 1162. And I'd like to have that marked for the record. Your Honor, I think this was marked yesterday.
AOB Exhibit 13 was marked yesterday, and witness Torinami verified that he was a sponsor of these data requests.
Okay, could you just check this data response, AOBA 13, Mr. Price, and see that you are listed with Mr. Torinimi as a sponsor of this exhibit?
While you do that, Mr. Price, Ms. Francis, I'm scrambling to get a copy. I'm deluged with hundreds of emails. If you're just going to authenticate with Mr. Price, I won't.
No, I'm going to ask him some questions. I said yesterday, questions.
If you could give me just one moment then, please.
Take your time. I could use a sip of coffee.
I have it now. Thank you.
Okay. Mr. Price, do you have that exhibit?
Yes, I do.
Okay, and Your Honor, for the record, as I stated yesterday, this was filed in formal case number 1162. Can you also verify the accuracy of this data response, these data responses?
Yes, they are accurate.
And just for the record, these responses were filed on October 1st, 2020. Is that correct?
Correct.
Okay.
Well, let me take that back. I don't know that I have.
Look at the
Oh,
date.
yeah, they are dated. Okay. Yep.
They're both dated. Do we agree?
Yes.
Do the company's responses to AOBA data requests 9-6 and 9-7, informal case 1162, AOBA Exhibit 13, do those data responses address the contributions of various factors to the company's lost and unaccounted for gas percentage?
No, I don't believe that there's any measurements contained in that per each of the factors.
That was my second question. So we'll stick with that answer, but I just want to put it in context. This data response requests, has the company assessed, take a look at the first question in 9-6, the extent to which each of the following has contributed to its reported lost and unaccounted for gas percentage for the test year in this proceeding. And then it goes on to list A through G: leaks, third-party damage, inaccurate customer meter readings, inaccurate gate station readings by interstate pipelines, use of inaccurate heat values per therm of gas, theft of service, and other. Is that correct?
That's what the DR says, yes.
And in the last sentence in the company's response to Part A, it says no quantification has been performed. Is that correct?
Correct. That's in reference to the AOBA reference to witness Tornimi's testimony at 113, 114, and the last paragraph of that response related to his testimony does read exactly as you stated.
Okay, now let's go to the next paragraph where it cites company witness Price's testimony in formal, it doesn't say formal case 1162, but that's where this was filed. Company witness Price's testimony in that proceeding. And the last sentence says, therefore, no quantification has been performed. Do you agree with that? That's in reference to your testimony.
That is what the last sentence says.
Okay. Okay, now, Your Honor, let me just check my notes. I think I lost my place. Now, does your response to AOBA data request 9-6, AOBA 13, also suggest that the factors listed can influence lost and unaccounted for gas and makes no assertion that they in fact contributed to its reported lost and unaccounted for gas percentage?
To put the response in context, referred to my testimony that caused the data request. That testimony was by Mr. Oliver and was limited to the suggestion, as I interpreted it, that the increased leaks created such a factor contributing to lost and unaccounted for gas that somehow that should be basis for disallowance of an adjustment related to that. My testimony and my response here that is connected to was to point out that a very limited point, Your Honor, very limited point, and the point is this, that because of the leak management practices, and in this case, obviously it was in the District of Columbia, but our leak management practices are consistent. that it is an overstatement to suggest that leaks present such a contributor to lost and unaccounted for gas without some quantification that there should form the basis of an adjustment. And those practices are essentially two. One is with respect to grade 1 leaks, when they are identified, they are repaired then. They are worked continuously until they are repaired. So there isn't an ongoing leak with grade 1 leaks with respect to lost and unaccounted for gas. And with respect to grade 2 leaks, which can be managed in a less than continuous manner, they are also the result of a backlog in the District of Columbia. In that case, that was quite low. So again, did not make it could not form the basis of a significant contribution. So that's the context of the answer to 9.6. That's the context of my contribution to the answer of 9.6.
Were you listening to the hearings yesterday?
Yes. Yes.
Okay, so you did hear Mr. Toronimi state that this was an accurate response in regard to his input to it, did you not?
I'm sure he did. I don't specifically recall it, and I don't disagree with that. This is also an accurate response that I sponsored.
But what I hear you saying is, because you have not quantified the extent that unaccounted for gas, you have not accounted for how unaccounted for gas is reflected in how leaks are reflected in unaccounted for gas, because you have not accounted for that. We shouldn't take that into consideration. Is that what you're saying?
Your Honor, I'm going to pose a soft objection here. I think that question mischaracterizes a very full and complete response to a prior and similar question. So I would respectfully ask through the bench that Counsel for Aoba rephrase her question.
Your Honor, this is like the third time I've rephrased it, and I can't get an answer to it. The first time he addressed what Mr. Toronimi was saying in paragraph A. Now I'm following up on a statement that he made that because there was no quantification of how much of the leaks were reflected or mitigated in unaccounted for gas, because he didn't do that calculation, that point should be disregarded.
If I may, Your Honor, that is not what the witness just testified in response to Ms. Francis's follow-up questions on the second paragraph. What he said was that grade 1 leaks are remediated immediately and therefore are not a contributing factor or a contributing factor to loss.
Your Honor, could the court reporter read back his answer rather than having Mr. Dodge?
My objection stands. If I'm not going to be able to speak to it, I'll just stop and relodge the objection.
Mr. Dodge, finish your objection.
As I was saying, Your Honor, thank you. The first part of Mr. Price's response was that grade 1 leaks are remediated immediately, and therefore do not constitute a material contributor to lost and unaccounted for gas. He also said that there was a very low backlog of grade 2 leaks in the District of Columbia, the location and jurisdiction from whence this discovery scuffle apparently emanated, that they could not themselves form a material contributing factor to lost and unaccounted for gas. That is entirely different from Mrs. Francis's characterization that we have not done that quantification.
Your Honor, shall I respond?
It was Mr. Dodge's objection. Listen, I heard what the witness said. We don't have live notes in this case, so the witness's response can't be read back, but I heard what the witness said. The testimony speaks for itself. I think that there is, within the words of the response and within the words of the data response that's in evidence number AOBA 13, and within Mr. Price's live testimony just now, I think both attorneys have adequately stated what has been Mr. Price's testimony. So for that reason, I'm going to allow Ms. Francis to ask the question.
Okay, let's just go over one last time. Washington Gas's response in paragraph A, it does say that, quote, it identifies factors that can influence lost and accounted for gas and makes no assertion that they contributed to its reported lost and unaccounted for gas proceeding. And then it says there is therefore no quantification has been performed. Then the question in regard to your testimony, would you agree? It says that your testimony was in regard to a response with respect to lost and counted for gas is only limited to leak management practices with regard to grade 1 and grade 2 leaks, and that you are likewise making no assertion that they contributed to the lost and unaccounted for gas, but you did not perform a quantification. Correct?
That's correct.
Okay. I'm going to move on, Your Honor. Now, could you please focus on what was identified yesterday and admitted into the record, which was AOBA 14. Your Honor, I don't need to identify what's in that again, do I?
No, but AOBA Exhibit 14 was Washington Gas response to AOBA Data Request 3-2, WGL's 2019 Annual Report to PHMSA, DC Public Service Commission formal case number 1162. So there you go.
Okay, thank you. Do you have that, Mr. Price?
I'm pulling that up right now. It's not opening up through my zip file. Let me see. Okay. Thank you, Ms. Ward. Let's see if that comes up. Okay, I have that up now, Your Honor.
Okay. I believe Mr. Turanimi verified yesterday that attachment 2, which is what I would like you to look at, provides a copy of the company's 2019 annual report to PHMSA for its Maryland distribution system. Do you agree with that? Did you hear my question, Mr. Price?
I did. I'm sorry, Ms. Francis.
No, take your time. Take your time. I just want to make sure you heard my question.
Yes, I think that is accurate.
Okay. Now, in the bottom right-hand corner of attachment 2, on page 3 of 4, we find a box labeled Part G. Percentage of unaccounted for gas. Do you see that?
Yes, I do.
Okay. What is the percentage shown in that box for the 12 months ended June 30th, 2019?
4.3%.
Before I go on, I just want to get back to an earlier statement where we were discussing the response to the data requests, AOBA Exhibit 13. If Washington Gas hasn't quantified the gas list as listed in that response, 9-6, as a result of grade 1 and grade 2 leaks, isn't any assessment of how material those leaks are in the determination of lost and unaccounted for gas, isn't that speculative?
Well, again, my testimony in that case and the sponsored DR response was to actually point out what appeared to be an overemphasis by Mr. Oliver at focusing on leaks as opposed to many other causes of lost and unaccounted for gas. So I didn't propose to, and I didn't testify to a quantification method. What I was rebutting was the notion that somehow an increased leak trend somehow become as significant as Mr. Oliver was suggesting. That is the limit of my testimony.
I understand that, but whether you're making a determination whether it's material or whether Mr. Oliver overemphasized something, without a quantification, any response is merely speculative. Isn't that correct?
Well, I wouldn't say any response is merely speculative. I did not attempt to quantify. I attempted to frame the relativity of the factors that were being discussed, and I think I did that.
Now, I'm going to ask you to please reference Mr. Oliver's testimony at page 8.
Which testimony?
His direct. And I'm going to ask you now to focus on his lines 11 and 13. And on those lines, Mr. Oliver asserts that Washington Gas's unaccounted for gas percentage, I'm quoting, is now more than 4 times the industry average, end quote. Am I correct that neither you nor any other company witness in this proceeding refutes witness Oliver's testimony on this point?
I did not provide any testimony on that point.
Do you have any reason to dispute that witness Oliver's, that Washington Gas's unaccounted for gas percentage is now 4 times the industry average?
I don't have any basis upon which to find that.
Your Honor, one moment. Now I know I'm missing something. You were a witness in the DC case, formal case number 1115 and 1154. That was this fall before the DC Public Service Commission.
I am
Okay, and in fact, you submitted
not certain of the case designations, perhaps subject to
the Stride. It was a rape case, but it had combined case 1115, 1142, and 1154. You in fact had direct testimony in that case.
I trust you're accurate there, Ms. Francis.
But I want to say that accurately. You in fact filed supplemental direct testimony and rebuttal testimony in that case. Do you agree with that?
Again, I would probably ask Mr. Dodge to just verify that. I certainly have provided testimony in the DC cases, but your designations I don't have at my fingertips.
How
We will
about,
accept them subject to check.
yes, okay. That's just what I was going to say.
Mhm.
Do you remember that in that case, they cited the industry average for unaccounted for gas percentage for 2019 was 1.03%, while Washington Gas reported unaccounted for gas for 2019 for 4.30%. Would you accept that subject to check?
Yeah, I have no personal record of that, but subject to check. I would accept whatever Washington Gas witness testified to in that regard.
Now, you did not refute Mr. Oliver's testimony, his direct testimony in this case, that Washington Gas's unaccounted for gas percentage is now more than 4 times the industry average.
I think I've answered that, correct?
Did you refute that statement by Mr. Oliver in your testimony in this proceeding?
Objection asked and answered.
Yeah, but I've already told you I did not.
Okay. What, other than the increasing frequency of leaks, explains the comparatively high level of unaccounted for gas that Washington Gas has reported in recent years?
I think there could be any number of explanations based upon the other factors that contribute to these. And just as an example, and I'm not testifying that they did or they didn't, but your question is what other factors could contribute? Any one of those other factors could contribute, any one of them.
And those factors that could contribute, that's what we were exploring in the response to AOBA 9-6, correct?
Those factors are listed in 9-6, correct?
Okay. Now, am I correct that Washington Gas has not performed a study to estimate the volumes of gas impacted by third-party damage in each jurisdiction?
Your Honor, again, I hate to be an objection machine, but this is clearly well beyond the scope of Mr. Price's filed rebuttal testimony.
Your Honor, we disagree.
Overruled.
Shall I repeat the question?
No, I think I recall the question. To my knowledge, we have not performed such a study.
Has Washington Gas presented any evidence in this case that demonstrates incidents of third-party damage are more frequent on its system than on the system of other gas distribution utilities across the United States?
No, we have not performed the study of frequency of third-party damages relative to other distribution systems.
Have you presented any evidence that Washington Gas's meters are significantly less accurate than those for other gas distribution utilities?
No, to my knowledge.
Has the company presented any evidence that Washington Gas is subject to greater amounts of theft service than other gas distribution utilities?
No.
Has the company presented any evidence that it encounters more frequent or more substantial meter reading errors than other U.S. gas distribution utilities? I'm sorry, I just didn't hear you.
Sorry, not to my knowledge.
Is Washington Gas more likely to be affected by inaccurate gas station readings than other gas distribution utilities?
I would not know.
You don't know?
I don't know.
Is it the company's position that Washington Gas is more prone to the use of inaccurate heat valves per therm of gas than other utilities?
Yeah. Clarification, I think the questioner may have meant heat values, not heat valves.
Values, I'm sorry.
And also, I believe in the last question, you may have meant inaccurate gate station readings.
Did I mistake that? Okay, just means I can't read my own writing. Inaccurate gate station readings.
Yeah, with those, yes, thanks.
Do you want to go back and revisit your last answer, Mr. Price?
No, I understood the correction to heat values, and I don't have a basis to. I forget how you formed your question, but I don't have a basis to suggest that there are differences.
Now, at page 9, lines 18 through 20 of your rebuttal, you state, I'm going to quote, "The practice of immediate repair of hazardous leaks mitigates the impact of emissions from hazardous leaks," end quote. Do you see that?
Correct.
In fact, even with what you characterize as immediate repair of a greater number of annual leaks of hazardous leaks, that will tend to contribute more unaccounted for gas and more emissions of greenhouse gases than a lesser annual number of hazardous leaks. Isn't that correct?
That's not necessarily true. It obviously depends upon the nature of the leak. So it's not strictly an issue of numbers. It's an issue of the individual leaks.
Mr. Price, maybe I'm missing something, but the more leaks you have contributes to more unaccounted for gas, and obviously to the emission of greenhouse gases. Don't you agree with that statement?
I think the way I phrased it earlier is that increasing leaks can impact lost and unaccounted for gas. Your most recent question prior to this last one seemed to want to simply say 11 leaks, for instance, are worse than 10 leaks. And that implies that every leak with respect to the escaping gas and the volume of emissions are equal. And my point was that they are not. So it isn't strictly a matter of quantity.
My question never assumed that the amount of gas that's unaccounted for or from leaks is equal across leaks. What my question went to very specifically was when you have more leaks, a growing number of leaks, and there are more of them, that does contribute to more emissions of greenhouse gas. Isn't that correct?
I think I answered that earlier in the testimony, that I do think the quantity of leaks have an impact on that.
Your Honor, I'm just checking my notes, and I want to make sure that if I asked this question before, I'm sure Mr. Josh will jump up. Can you tell me, how is unaccounted for gas reflected in delivery service customer bills?
No, I cannot tell you that.
I think this is my last question. Would you agree with me that the company's tariff currently on file for residential delivery service customers, rate schedule 1A, firm, commercial, and industrial delivery service customers, rate schedule 2A, firm, group metered apartment delivery service schedules, rate 3A, rate schedule 3A, and interruptible delivery service rate schedules number 4, all delivery service tariffs. Would you agree that each one of those customer groups' tariffs has the same provision that states the amount of gas retained by the company shall be a percentage equal to the percentage of lost and unaccounted for gas experienced in the company's sales service during the billing month? Would you agree with that?
Subject to check, Ms. Francis, I would agree that any tariff that Washington Gas has filed with the commission says what it says.
And the point of that question, Mr. Price, isn't that the tariff says what it says. That's obviously true, and I can put that in a brief. The point is that lost and unaccounted for gas, since it is reflected on customers' bills in the delivery service portion of their bills, that it does have an effect on the rate that delivery service customers pay, correct?
Again, if that is in the tariff and that is accurate reading of it, which I have no reason to think it isn't, Miss Francis. I'm not trying to be cute. I just don't have it in front of me.
No, I understand that.
So if that's what it says and that's where it appears, then I have no reason to to disagree with that.
I just want to get my exhibits in, Your Honor, make sure I got them all. Your Honor, at this time, I'd like to enter into the record what was previously identified as ALBA Exhibit 13 and what was identified yesterday with the boost from Mr. Price today as ALBA Exhibit 14. I'd like to enter those into the record.
ALBA Exhibit 13 and 14 are admitted.
And thank you very much, Your Honor. I am done with Mr. Price, and I am done cross-examining the company's witnesses unless something new comes up.
Yes, ma'am. Thank you.
Thank you.
Montgomery County, Ms. Brennan, does Montgomery County have cross-examination?
Yes, Your Honor. Thank you. Good afternoon, Mr. Price. My name is Lisa Brennan. I represent Montgomery County, Maryland. I don't believe we've had the pleasure of meeting before.
I don't think so. Good afternoon, Ms. Brown.
I'd like you to turn to your rebuttal testimony, please. This has been identified by Washington Gas as Exhibit 22.
Okay.
And specifically, I'd like you to turn to the section starting on page 4 that discusses the merger commitment 11B.
Okay.
So on page 4, starting at line 10, going through 14, you quote the language from 11B, commitment 11B, and I just want to highlight for this discussion the last sentence, which says, this report will propose a specific leak mitigation process or other specific measurable safety measures in the Washington Gas Maryland service territory, the costs of which will be $4 million and will not be recovered by Washington Gas and utility rates. You with me?
I'm with you.
Okay, and you note just in the next section, after the next question on line 17, you confirm that the company did file that report on July 8th, 2019, correct?
Correct.
So, and for the record, that report is actually attached to company witness Turanini's rebuttal as an exhibit RET R4, in case you need to refer to it.
Okay, thank you.
I don't have questions about the specific report, a specific section of the report, but just in case you decide to look at it. Referring back to your rebuttal on page 5.
Okay.
Starting at line 17. You talk about the illustrative list submitted in July 2019. You see what we're talking about?
Yes.
Are you aware of which costs in this illustrative list have been identified that would be have been excluded from recovery by Washington Gas and utility rates per this commitment?
So just so I understand your question, per Mr. Tornimi's testimony, I think he was clear that this was not a line item off this list that was identified, but that these initiatives all had costs to them. They were not prospective. They were real initiatives that we engage in. They all had costs, and that and I have to defer to Mr. Tornimi on this point, but that I have no doubt those costs actually exceeded $4 million, and then he has testified to the mechanism by which at least $4 million was not recovered in rates. So I hope that was an answer to your question. If it wasn't clear enough, I'd be happy to try again.
Well, let's follow up then on what your testimony says, so I'm clear. Turning to page 6, starting on line 4. You with me?
I'm with you. Yeah.
Okay. It states, rather, the only reference to costs is the requirement that $4 million of the costs for a specific leak mitigation process or other specific measurable safety measures in the Washington Gas Maryland service territory will not be recovered by Washington Gas in utility rates. Is that correct?
That's the correct statement of my testimony.
Okay. And then on page 7,
So can I, if I can, the rather caused me to go back and look at the question that I was responding to there. The question that I was responding to was a statement by staff witness that the commitment somehow required was that would aid in the reducing leak management costs. So that's what that was response was directed to. I just wanted to put it in context, and I can move on to the next question.
but you do state that the only reference to costs is the requirement that $4 million of costs for a specific leak mitigation process or other specific measurable safety measures in the Washington Gas Maryland service territory, quote, will not be recovered by Washington Gas and utility rates, end quote, correct?
Correct, that's true.
Okay, thank you.
Mhm.
So turning to page 7, starting at line 15. Well, I guess let's start it at, I guess this would be 12. You say, the commission agrees with the company's interpretation of merger commitment 11B per the language on page 43 of order number 88631. And then you go to quote what the merger order says, which is, this is their description of how they describe 11B. Therefore, the commission has ordered Washington Gas to propose in its safety report pursuant to paragraph 11B of the settlement, a specific leak mitigation process or other specific and measurable safety program, the costs of which shall be at least $4 million, not to be recovered in rates. So in that paragraph, does the phrase, the costs of which shall be at least $4 million, not to be recovered in rates, refer to the specific leak mitigation process or other specific and measurable safety program?
Yes, that would be our interpretation.
Your Honor, I believe that's all of my questions. Thank you, Mr. Price.
You're welcome. Thank you.
We'll turn to OPC for a cross-examination.
Thank you, Your Honor. Good afternoon, Mr. Price. OPC has no questions for the witness. Thank you.
And neither does staff, Your Honor.
Mr. Dodge, we'll turn to you for a redirect.
No redirect, Your Honor. Thank you.
Mr. Price, I have no questions. Thanks for your appearance this afternoon.
Thank you very much, Your Honor.
Is everyone okay to proceed with the next witness at this point, or does anyone need a break? Okay, Washington Gas, you can call your next witness.
Thank you, Your Honor. Washington Gas now calls Donald Klassen to the stand.
Can y'all hear me okay?
I can hear you, Don. I can't see you, but I can hear you. There you go.
Hi.
Mr. Klassen, will you raise your right hand, please? You swear or affirm that the testimony you're about to give is the truth?
I do.
Can you spell your last name for the court reporter, please?
Last name is spelled C-L-A-S-S-E-N. S-E-N as in Nancy.
Mr. Dodge, your witness.
Thank you, Your Honor. Good afternoon, Mr. Klassen.
Hi,
By whom are you employed, sir?
I'm employed by Washington Gas Light Company.
How long have you been with the company?
4 months and 1 week.
Congratulations to you, too. What is your current position with Washington Gas?
I'm the Vice President of Utilities Technology.
Mr. Klassen, are you the same Donald Klassen who caused to be filed in this proceeding on December 8th, 2020, rebuttal testimony?
Yes.
Am I correct, sir, that your rebuttal testimony consists of 10 pages of narrative questions and answers?
Yes.
Are there any exhibits associated with your rebuttal testimony?
I do not believe so.
Is there any confidential material contained in your rebuttal testimony?
No, there is not.
Your Honor, I believe we're now up to 23, and I would ask that Mr. Klassen's testimony be marked as WGL 23.
WGL 23 is marked.
We would also move its admission.
Any objection? WGL 23 is admitted into the administrative record.
Thank you, Your Honor. Mr. Klassen, was your rebuttal testimony prepared by you or under your direct supervision or control?
Yes, it was.
At this point, do you have any corrections, changes, or updates to make to your rebuttal testimony?
No, I do not.
If I asked you the questions presented in your pre-filed testimony, would your answers be the same today?
Yes, they would.
Do you adopt this testimony as your own in this case?
Yes, I do.
That's it for the qualifications, Your Honor. I do have some rejoinder for the witness at your pleasure.
Go ahead, Mr. Dodge.
Thank you, Your Honor. Mr. Klassen, are you aware of Office of People's Counsel witness Coppola's concerns regarding the company's so-called asset refresh program?
Yes, I am.
Are you aware that Mr. Coppola has proposed certain cost disallowances regarding that asset refresh program?
Yes, I am.
At page 51 of his surrebuttal testimony, Mr. Coppola criticized the company for retiring laptops after 2 years of use. Can you explain why the company did that?
Yes. The devices that we had at that time carried a 2-year warranty, and that warranty had expired. And in addition to that, the devices we had were designed specifically to run an operating system called Windows 7, the previous version, well, 2 previous versions technically of the Windows operating system. And we had decided that we needed to accelerate our purchases to use devices that were designed specifically to run Windows 10.
Thank you, sir. Also on page 51 of his surrebuttal testimony, Mr. Coppola criticized the company for raising, well, actually specifically you in your testimony for raising, and I'm going to try to quote accurately here, quote, potential errors in billing customers if the desktop and laptop computers or software were not replaced. Do you recall that criticism?
I do recall that in the surrebuttal, yes.
Did you raise billing concerns in your rebuttal testimony?
No, I did not.
Finally, Mr. Klassen, again on page 51 of his surrebuttal testimony, Mr. Coppola claims that, and here I'm going to quote again, the company has corporate-wide cybersecurity firewalls and systems in place which are far superior to anything included in Windows 10 or the laptop computers, end quote. His suggestion is that because of that, Washington Gas did not need to replace the laptops in question. Is that your interpretation of his claim?
That is how I interpreted the claim, yes.
And could you address that claim, please?
So we do have a number of different security solutions in place, including firewalls, but we still need to have the operating system updated on a regular basis for known vulnerabilities, have agents on those devices as well to protect the individual devices. If I try to put it into layman's type terms, it's similar to a firewall is a perimeter device, very much like a fence around a site, right? So in the same, or a secure entry door to an apartment building. Saying we wouldn't need agents or updates on the laptops is like saying we wouldn't need locks on the assets that are inside those perimeters. So like I wouldn't need a lock on the door of a building inside the fence, or I wouldn't need apartment locks on the doors of the apartments within, because I have a secure door at the front. So we use both. We use that and a whole lot more to make sure that our assets are protected and our information is protected. And the individual operating systems need to be kept up to date as a part of that.
Thank you, Mr. Klassen. I have no more rejoinder, so the witness is available for cross.
Mr. Cleaver, does OPC have cross-examination?
No questions, Your Honor.
Does staff have cross-examination?
No, Your Honor, we do not.
Thank you, Mr. Clayson, for your appearance this afternoon. And you are released. WGL, you can call your next witness.
Thank you. At this time, I would call in my colleague, Mr. Kane, for the purposes of bringing our next witness onto the stand.
Good afternoon, Mr. Kane.
Good afternoon, Your Honor. Your Honor, I'd like to call Mr. Paul Robb to the stand.
I see you, Mr. Robb. Rob, I see you raise your right hand. Do you swear or affirm that the testimony you're about to give is the truth?
I do.
Can you spell your last name for the court reporter, please?
Yes, my name is Rob, R-A-A-B.
Thank you. Mr. Kane, your witness.
Thank you. Mr. Robb, could you please give us your business address?
Yes, my business address is 5313 Portsmouth, P-O-R-T-S-M-O-U-T-H Road, Bethesda, Maryland, 20816.
And Mr. Robb, who are you employed by?
I am employed by myself.
Okay. And what exactly do you do?
I have a small consulting firm, very small consulting firm, and I provide consulting services to energy utilities throughout the country, natural gas and electricity, of course.
I see you have published several professional journals and spoken at a number of industry conferences. Do any of your published or industry conference talks involve electric and gas conservation, as well as rate design and cost estimation?
Yes, and I won't bore everybody with the specific papers and so on that I presented with respect to those topics. For those of you who are, or given the intent of your question, you're probably most interested in conservation. And for references with respect to that particular topic, I would point to my exhibit PHR1, page 10 of 12. The first 2 points on there, natural gas as an electric DSM tool, electric to gas fuel switching fall into that category. And certainly down at the bottom there as well on that page, natural gas price elasticity estimation, and avoided cost concepts and management considerations would all be related to the kinds of topics that you've discussed or raised issues about.
And how long have you been a consultant in the energy industry?
Sad to say, 45 years.
Congratulations.
Thank you.
What role do you have in this proceeding?
I have been asked by the company to respond to the testimony of witnesses, and I'll probably butcher this, but staff witness Olivia Kuykendall, and I apologize if I'm butchering that, and OPC witness Glenn Watkins.
Okay. Are you the same Paul Robb who filed rebuttal testimony that consisted of 29 pages of question and answers, as well as exhibits PHR1, PHR2, PHR 3, and PHR 4?
Yes.
Your Honor, we would like to have that testimony marked for identification purposes as, I believe we're at WGL 24.
WGL 24 is marked. Is there any objection to its admission at this time? Without objection, WGL 24 is admitted.
Thank you, Your Honor. Mr. Robb, was your rebuttal testimony prepared by you and under your direct supervision?
It was.
Do you have any corrections or changes or updates to make to your rebuttal testimony?
I do not.
If I were to ask you questions in your pre-filed testimony, would your answers be the same?
They would.
Okay. And do you adopt this as your testimony today?
I do.
Your rebuttal testimony has already been moved into evidence. And so my next question is, did you review the direct rebuttal and rebuttal testimony filed by the Office of People's Counsel witness Watkins and staff witness Kuykendall in this proceeding?
I did.
Okay. And I'd also like to ask you, have you testified previously in regards to the declining block rate structure?
Yet many times, I think in this jurisdiction, the last time I testified was in, with respect specifically to declining block rates, was in 9180, I believe.
Okay. I have some questions for Mr. Robb for live rejoinder.
You can proceed with rejoinder based on rebuttal.
Thank you, Your Honor. Mr. Robb, on pages 10 through 11 of staff witness Kuykendall, and I apologize if I butchered your name, but Kuykendall's rebuttal testimony at page 11, lines 1 through 2. He states that your intra-class cost of service study is based upon the company's recommended cost of service study. She further states that, quote, I do not have full confidence in its results. What is your response to that?
Sure. Ms. Kuykendall says that she does not have full confidence in the results, only not because she disagrees with the methodology that I rely on to develop that study, but because she disagrees with the cost basis upon which that study was developed. She says that she favors the study that was developed by staff witness Hauer, and presumably one can draw the conclusion from that if we were to rely on Hauer's cost of service study, then she would agree with the intra-class cost study. So I did that exercise, and I prepared an exhibit which is in some preliminary stages of being admitted as Exhibit X that's been provided to the parties. And Exhibit X does nothing more than take the unit cost from Afton Hauer's class cost of service study and generates the same intra-class cost study results that I generate using both of the company class cost of service studies. The Exhibit X that presumably we will get to at some point is in two general sections. The first shows the first part of that exhibit shows the specific cost levels associated with the various levels of consumption. And then the bottom part of that is the graphical presentation of the intra-class cost study. The top portion corresponds exactly to my exhibit R3, and the bottom portion corresponds exactly to my exhibit R4, but addresses witness Kuykendall's concerns with respect to not relying on a cost of service study that she favors. And what I would draw, and I would draw the conclusion from looking at that study that the company's current rate design accurately reflects the reality that lower usage customers impose greater per unit costs on the system and should therefore pay rates that reflect higher per unit costs. That comes directly from Howard's study and putting them through my intra-class cost study. It also demonstrates that either the system charge or the initial block rate for the residential heating and cooling class customers is too low. And it demonstrates that neither the company's existing declining block rate nor the alternative flat rate proposed by Mr. Watkins and by staff witness Kuykendall is superior in terms of matching the cost of service to the amount that customers pay for this service. Exactly the same conclusions that I draw using the company studies.
Your Honor.
Mr. Kane, can I interrupt for just one moment? Can you have your staff email what's been pre-marked as WGL Exhibit X to myself and to the parties?
Yes, Your Honor. And also we would ask, Your Honor, that be marked as WGL number, I believe, 25 for identification purposes.
Hang on just a second. I'll ask the parties. Does everybody have what was pre-marked as WGL Exhibit X in front of them? Okay, is there any objection to WGL Exhibit X? I'm going to mark WGL Exhibit X as WGL Exhibit 25. I'm going to wait for its admission. I just want to take a look at it first. I can't seem to put my finger on it as we speak. There's so much paper in this case.
I understand, Your Honor.
Thank you.
Your Honor, this is Mr. Dodge. We are working on getting you that new exhibit, and it should be emailed in the next few minutes.
Thank you, Mr. Dodge. I'm looking for it myself now through email, so we'll see who finds it first. Thank you. Thanks for your patience, everyone. Mr. Kane, you can proceed.
Okay. Your Honor, Mr. Robb, was this prepared by you or under your supervision?
Yes, it was.
Your Honor, we would like to admit this as WGL number 25.
WGL Exhibit 25 is admitted.
Thank you, Your Honor. Mr. Robb, on page 11, lines 5 through 14 of Ms. Kuykendall's rebuttal testimony, she stated quote, on the basis of a 2-year pilot program to study how customers respond to TOU, which is time of use pricing, which include off-peak hours where the price of electricity is less expensive than peak hours. Ms. Kuykendall concludes that changing WGL's rate structure from declining block rates to flat rates is a price signal that would have a similar effect. What is your response to that conclusion?
Well, I would agree with I believe Ms. Kuykendall's apparent conclusion that by sending a time of use price signal, she is actually, or the company is actually encouraging behavior where you're getting shifts. But the point that I was making in my testimony related to the individual components of the rate design, so that what I argued and what the literature shows, or at least the literature that I was familiar with up to that point, which was particularly a study by Ito out in California, was that the individual components of a rate really don't make any difference. Ms. Kuykendall, I believe, draws up the time of use study and say, no, they do make a difference because people respond to that. But she didn't read that carefully enough. And to that end, I would refer her to the section F on pages 52 and 53 of the report. On page 52 of the report is a figure 39, which summarizes the price elasticities in the summer. And you'll see down in the second row that there's daily demand elasticities, and there's a bunch of figures listed there, which may or may not be meaningful to anybody. But the critical point here is if you go back to 53, the authors of the report themselves conclude that the daily demand elasticities we estimate for the summer period are generally negative, but, and this is an important but, with the exception of DP&L, not statistically significant. That is precisely Ito's point. People don't respond to individual prices. And that led me to my conclusion that it really doesn't matter what you do with respect to the declining block rate. People don't respond to those price signals. They respond in general to an overall price, which is what this report suggests, the PC 44 report suggests, and what Ito suggests. People respond to broad price signals. They don't respond to individual price signals at that granular a level.
Okay. Mr. Robb, I would draw your attention to pages 3 through 7 of OPC witness Watkins' testimony. In his testimony, he criticizes your intra-class cost of study and defends his intra-class study. He calls your study seriously flawed. He claims your simple extrapolated various allocated, that you simply extrapolated various allocated costs from the company's intra-class cost of service study, wherein you related, quote, recovery of the company's allocated total fixed cost, customer related and demand related, to residential consumption levels. Do you have a response to that?
Yes, and I'll try to be brief. There's obviously a lot here, but let me just hit the high points here. Mr. Watkins' primary claim is that I just extrapolated these various allocated costs and I come up with this cost, and that somehow doesn't satisfy his requirements of what an intra-class cost study really is. The only way I know how to do an intra-class cost study is to develop billing determinants and apply costs to them and compare those costs to what revenues are being collected under bills. There's just no other way. And I don't think you can put some load factors up or put some load descriptions or descriptions of how customers use electricity up and call it cost, particularly when there's not a cost figure anywhere in his testimony. So, but what I would say that the big problem I have with what he's saying is that on page 8, lines 12 to 13, he says, while there is no doubt that the vast majority of WGL's distribution costs are sunk or fixed costs in the short run, all costs are variable in the long run. Now, I don't know what that means in terms of doing an interclass cost study, but I think whenever I get crazy statements like that, I generally tend to go back to Bondbright and see what Bondbright says about that. Bondbright on page 397 of his text, he says, in the first place, and this is a quote, in the first place, in treating the total cost of the business as if it varied directly with changes in the kilowatt hour output of energy, his words again, a grossly false assumption. It violates the most widely accepted canon of fair pricing, the principle of service at cost. So there is no greater authority in my mind than Bondbright on rates, and he says that's just a crazy idea. With respect to my way of defining cost components, Bondbright goes on to state, and that was on page 397 in case I didn't provide it to anybody. He goes on page 400 to say, the two-part rate distinguishes between the two most important cost functions of an electric utility system, between those costs that vary with changes in the system's output of energy and those costs that vary with plant capacity and hence with the maximum demands on the system and subsystems that the company must be prepared to meet in planning its construction program. That's on page 400. So I don't know what foundation Mr. Watkins would have for arguing that it's not appropriate to include fixed costs and customer costs and all the other costs we identified in a cost of service study to do an interclass cost study, but he is clearly at odds with Professor Bondbright on this issue.
Okay. And you when you were referring to pages 397 and 400, you were referring to what again?
Oh, I'm sorry. That's Bondbright's Principles of Public Utility Rates.
Okay. On page 10 of OPC, witness Watkins' rebuttal testimony, he also criticizes you for asserting that the declining block rates do not promote energy conservation due to price elasticity of demand for natural gas. He acknowledges that natural gas is inelastic and the price of gas increases. The demand increases. He also states that based on economic theory and public policy, the declining block rate does not promote energy conservation. What are your thoughts?
Well, I think my rebuttal or my rebuttal testimony addresses that topic, but I guess the only other point that I would make is that once again, Mr. Watkins' testimony flies up in the face of reality. And to make that point, I would say, you know, he's arguing we're not going to get these shifts because natural gas enjoys such a price competitive advantage over electricity. Well, if one goes back and looks at the data that's starting to come in on this subject, and I went back and looked at the 2015 Residential Energy Consumption Survey of the US EIA report, and that report states as follows: trends in space heating are partly responsible for the increase in all electric homes in the United States. In 2015, electricity was used as the main source of energy for space heating in 36% of homes that were heated, an increase from 2009 that continues a long-term trend. So I would say, thus, you know, despite his assertions to the contrary, natural gas to electricity fuel switching is common and it's getting worse, and it doesn't matter whether he claims there's an advantage or not.
Okay. Your Honor, we would like to, I've concluded my live rejoinder questions, and Mr. Robb is available for cross-examination.
Office of People's Counsel, do you have cross?
Very briefly.
Good afternoon, Mr. O'Laughlin.
Good afternoon. Good to finally have my face shown on here, and thankfully my 2-year-old son is not around to jump in as well. Save you, he's relentless on cross himself, but mostly about snacks. Good afternoon, Mr. Robb.
Good afternoon, Mr. Laughlin.
Just a couple of quick questions. So you just spoke a little bit about the topic of declining block rates and energy efficiency.
Yes.
Are you aware of any guidance from this commission on that topic?
Well, in a general sense, of course. I mean, they're sort of anti-declining block rates. I think, and let me just, before I say anything else, say that the commission has wide discretion to set whatever policy they want with respect to rate design and with respect to many, many other issues. The only point I would make here is that if they set that policy, they're doing it without the basis of any analytical support whatsoever, because there is no study that shows that declining block rates will have the impacts that they believe, I think they believe they will have with respect to their policy of promoting energy conservation in the state of Maryland.
Your Honor, if I could get sharing privileges for just one moment.
Hang on just one second.
Thank you. I'm going to pull up what's been marked already as OPC Exhibit 10. It's order number 89072 from the Potomac Edison rate case about 2 years ago, case number 9490. So let me see if I can actually manage to share this.
I believe that OPC Exhibit 10 was previously marked, but I'm going to go ahead and mark it for the, I don't think it's marked in the record, so I'm going to go ahead and mark it for the record. Commission order number 89072 and case number 9490.
Thank you, Your Honor. I'm going to direct you to what is page, I believe, 109 of the decision here. And it's the second sentence of the first paragraph in this commission order. I don't know if my highlighting is showing up. Is that showing up?
Yes.
Yes, it is.
Do you see where the commission in a 3-commissioner panel stated flatly and plainly, declining block rates also discourage energy efficiency?
And that's no different than anything I've agreed to. I mean, they say they do. There is no basis on which they make that statement, to my knowledge, though. Analytical basis. The econometrics don't support them.
Okay, thank you. Nothing further.
Does staff have cross-examination?
Hello, Your Honor. Yes. Good afternoon, Mr. Robb.
Good afternoon. How are you this afternoon?
Oh, thank you.
I've lost you. Oh, there you go.
I will just jump right into it. On rejoinder here, you just testified that you testified about staff witness Kukendial's. I'm sorry, may I please rephrase my question? If you could pull up page 12 of staff witness Kukendial's direct testimony. Staff witness specifically states that she is not arguing that customers respond to marginal prices, but that customers respond to the entire bill, correct?
She says that, but that doesn't follow for me. I got to tell you, that statement is just a total non sequitur to me. That's all she spends her testimony talking about, that they respond to individual components of the declining block rate. That's why she advocates that it be taken away. I don't get it. I mean, I'll accept whatever premise you have for purposes of answering your question, but that is just a flat, bald statement that doesn't make any sense to me at all.
Okay.
And maybe if we went back to her testimony and you could point that out to me where she does that, but everything I read, when I go back and read it 5 and 6 times, says that's exactly what she's saying. That's why she wants to do away with the declining block rate. There's no other reason for her to do so.
Okay. Thank you. Just give me a second here. So in contrast to volumetric rates, no matter how hard a customer attempts to conserve energy, a customer cannot reduce a fixed customer charge, correct?
Sure, but that's what the econometric says. They won't. They don't. There's no response to those prices. So they don't even attempt to change their bill because there is no observed price response to individual components of the declining block rate. So you can give them the gift, but they'll never use it.
Thank you. And on page 19 of your rebuttal testimony.
I'm sorry, page 19?
Yes, page 19. You believe that a reduction in inter and intra-class subsidies is the most important role that a rate structure can play in enhancing the Commission's conservation objectives, correct?
Yes.
And on page 18 of your rebuttal testimony, you state that the price elasticities of demand for energy are low, suggesting that any effort to achieve reductions in demand through the price of natural gas are not likely to be rewarded with large changes in consumption, and also suggests that customers are not likely to change their bills significantly by changing usage, correct?
Yes, except for the one point that I make there on page 19. I may have jumped back. I'm sorry. I was on 18, but I do point out a case where for those customers, the cross price elasticity between natural gas and electricity is very, very high. And I provided that information to Ms. Kuykendall in the form of data request staff 22, question number 1. It's the Rice and White article, and those elasticities appear right there on page 868 of the article, table 3. And what that shows is that the elasticity for those particular subgroups of customers do in fact go into the elastic portion, what an economist would consider elastic. Now, I'm not going to say it's big, it's 1.02, but it's there.
Okay.
So I don't mean to, I don't mean to work around your problem. I'm just saying there's a small subset of customers, the small segment of customers, and one that should be particularly important when we're evaluating conservation activities. And that subset shows something different than the rest of the class, the rest of the customers within that class show. That shows that they are relatively responsive to price, much more responsive to price than anybody else, and is fully consistent with the real world data we see from example, the RECS 2015 and all other saturation surveys that I've seen that show natural gas space heating dramatically increasing over the last 5 to 10 years.
Okay, well, that brings me to my next question. Isn't it true that there are upfront costs for a customer to switch from natural gas to electricity, such as the purchase of new appliances?
Of course, but they're all factored into that price elasticity estimate. They're not, the price elasticity estimate measures observed behavior. So they have embraced those front end costs. They have taken care of those front end costs and they've switched. And that's what's observed in the price elasticity quantification that we see in the Rice and White article. It's already embedded in there.
Right. So again, this price elasticity is observed, as you just said.
Yes.
Correct?
Yes.
So the time of use study filed in PC 44 shows that customers in Maryland respond to price signals by changing their usage, correct?
There's no dispute about that fact. But what the other important thing that shows that's been completely disregarded is that they do not respond to the individual components. They respond to the average bill, which is exactly what ETO found also, which is what I found many times in my elasticity research, but not the individual components of the rate.
Right. I think that we're all in agreement there.
Yeah, well, let's hope so. Then I've won.
Staff witness stated in their testimony that they also agree with you that they're responding to the average in the bill.
Yes.
And then Columbia and BG&E have uniform rates for residential customers. And are you aware of any complaints from these companies that their customer count or usage levels are decreasing as a result of not having declining block rates?
No, I mean, I don't do any work for BG&E and Potomac Edison. BG&E is probably less concerned about loss of load on one side of the system because they pick it up on the next. But I just don't know enough about it to be able to respond intelligently to your question. I mean, and again, my conclusion is not that we should not do away with the declining block rate. If you wanted to fix the fixed charges, you could do that. But I don't think you can do one without the other. And I don't know what they've done with their fixed charges either. I know that Potomac Edison raised fixed charges. I just don't know enough about their rate structures and what their strategies are and what they're trying to do to really give you an intelligent answer there. I'm sorry.
Okay, thank you. That concludes my questions.
Mr. Kane.
Yes, I have two redirect questions. Mr. Robb, was PC 44, wasn't that a study concerning electricity rather than gas?
It was, but I think its conclusions are equally, at least its conclusions generically with respect to rate design are equally germane for natural gas rate design.
Okay. I have no further questions.
Give me about a minute or so, please.
Okay.
Mr. Robb, I have no questions. Thank you for your appearance this afternoon.
Thank you, Your Honor. I'll be back in my hole.
Mr. Kane or Mr. Dodge, I believe you may have one more witness.
Yes, Your Honor. I'd like to call Mr. James Wagner to the stand. And there's Mr. Wagner.
Mr. Wagner, will you raise your right hand, please? You're still muted. You swear or affirm that the testimony you're about to give is the truth?
I do, Your Honor.
Thank you. Mr. Kane, your witness.
Yes. Mr. Wagner, could you tell us who you're employed by?
Washington Gas Light.
And could you give us your business address?
6801 Industrial Road, Springfield, Virginia.
And Mr. Wagner, how long have you been employed by Washington Gas?
33 plus years.
Congratulations. What is your current position with Washington Gas?
Assistant Vice President of Rates and Regulatory Affairs.
Mr. Wagner, directing your attention to your direct and rebuttal testimony, Are you the same James Wagner who filed direct testimony on August 28th, 2020 in this proceeding, which includes, I believe, 12 pages of question and answers, as well as exhibits JBW-1 through JBW-3?
Yes, I am.
Did you also file rebuttal testimony filed on December 8th, 2020 in this proceeding, which includes 12 pages of question and answers, as well as exhibits JBW-R1 and JBW-R2?
Yes, I am. That's correct.
Your Honor, for identification purposes, we would like to have both Mr. Wagner's direct testimony marked as, I believe it's WGL 26, and his rebuttal testimony marked for identification purposes as WGL 27.
WGL exhibits 26 and 27 are so marked. Is there any objection to their admission? Seeing none and hearing none, WGL exhibits 26 and 27 are admitted into the administrative record.
Thank you, Your Honor. Mr. Wagner, was both your direct and rebuttal testimony prepared by you or under your direct supervision?
Yes, it was.
Do you have any corrections or changes or updates to make to your direct and rebuttal testimony?
Yes, I do. One correction slash update on page 10 of the rebuttal testimony. In that, from line 3, actually, of the opening paragraph there, at the time of the rebuttal, those were the latest approved system charges by the Maryland Public Service Commission. Since the filing of that, Columbia Gas had entered into a settlement with rates that took effect in December of 2020. So that $15.40 rate is now $15.70. And also to the left of that, for Baltimore Gas and Electric, the commission issued an order last month in BG&E's multi-year plan, and they approved a approximately 7% increase in the system charge. It was $14.25, and the commission accepted BG&E's $15.25. I would note, though, that will take effect when the other rates are increased based on the commission decision in that particular case. So the commission order stated that it finds them reasonable, but set the effective date in the future.
Do you adopt both your, based on your updates and your corrections, do you adopt both your direct and rebuttal testimony as your own testimony in this case with the changes you highlighted?
Yes, I do.
Okay. Your Honor, since exhibits 26 and 27 have been admitted, the company has no rejoinder, and Mr. Wagner is available for cross-examination.
Mr. Cleaver, do you have any cross-examination for OPC?
No questions for the witness, Your Honor.
Does anybody else in the room have any questions for this witness from Mr. Cleaver's room? Okay, does staff have any cross-examination?
I have limited cross, Your Honor. Hello, Mr. Wagner.
Good afternoon, Counselor.
Good afternoon. You did not cite any commission precedent supporting your third step in revenue allocation, correct?
That's correct. In the company last case, 9481, the commission used a two-step process, which several witnesses in the case have used. Again, my third step was meant to increase parity. However, this is, as the company has described it, a precedent case. So I could agree that the two-step process gets us to a similar place where what I tried to do in 3 steps does.
Thank you. That's all the questions I have.
Mr. Kane, do you have any redirect?
No redirect, Your Honor.
Mr. Wagner, I have no further questions for you today. Thank you for your appearance.
You're welcome, Your Honor. Thank you.
Okay. Parties, it is Friday afternoon. We are at a natural stopping point because I believe, actually I should ask Mr. Dodge, Mr. Kane, do you have any other witnesses?
That concludes our case, Your Honor.
Thank you. Now we are at a natural stopping point. We've heard from all the witnesses from Washington Gas, and we have a few other witnesses that we need to take from some of the other parties. I propose that we end our hearings for the evening and begin at 10 o'clock on Monday morning. Does anyone have any objection to that? Ms. Francis has something to say.
No, I have no objection, but could I just ask the order of witnesses for Monday morning for planning purposes?
Well, I believe your witnesses have been excused, and GSA's witness has been excused. Montgomery County doesn't have a witness. So, Office of People's Counsel, is it going to be Mr. Coppola first?
Yes, Your Honor, he'll be available, and that works for us. And Mr. Watkins, we've confirmed, is also available Monday, and I believe everybody has waved cross on Mr. Garrett, so he won't be, he's watching, but he won't be logging in. But those 2 witnesses will be available back to back starting Monday.
I believe that's true. And then Mr. Wilson, I believe Miss Kuykendall has been released, but what is the order of your other witnesses? Mr. Wilson, you're muted, so I don't know if your face is turned, so I don't know if you're talking or if you're looking at your notes.
I was talking and looking at my notes. Yes, you're correct. Ms. Kuykendall has been relieved. Mr. Valcarengi will begin, followed by Negusi Tesfaila, who is our engineering witness, followed by Afton Howard, and Drew McAuliffe will be our final witness.
Okay, so we have OPC, Mr. Coppola and Mr. Watkins, and then we have staff, Mr. Valcarengi, Tesfaye, Howard, and McAuliffe.
Correct.
Thank you, Your Honor.
Your Honor, if I could just, staff had some questions concerning the paper copy that you want mailed to you. You want one copy of just the cross-examination exhibits, is that correct?
I want one copy of each party's exhibits that were admitted into the record. Only those that have not previously been filed in the case jacket, so no testimony.
Gotcha.
I want to make sure that what was intended to be with, everything was electronically delivered. And I have some of the things on my personal laptop over here. I have some of the things on my work laptop over here. And then I printed out a few trees over here. But I want to make sure that what I have that goes into the administrative record is exactly what was intended to go into the administrative record. And I leave it to the parties if it's, for instance, something that's really, really long and we're only referring to a couple of pages. It would be great if I would be fine with just limiting it to the title page, table of contents, and the relevant pages. That's just fine for the record.
Very good, Your Honor.
Your Honor, can I clarify one more thing?
Yes, ma'am.
You mentioned that if the documents were already previously in the case jacket, we didn't include them, but I believe when I was doing my cross-examination, you also discussed that if they are commission orders already on file in the commission, that they did not need to be included as well.
That's true. I'm looking at Montgomery County's pre-filed or pre-circulated exhibit list. I believe at this point we've marked 4, 5, 6, and 7 in the record, and I don't believe that 4, 5, and 7 need to be sent. 8, 6 you might want to send, and your other marked exhibits 1 through 3 look to be testimony that's already been filed in this case, so you might be limited to number 6.
I will just say that I wasn't sure about 6 because number 6 is actually an exhibit to Mr. Turinini's rebuttal. So it's actually already in file in his, I can refer to it in anything that I cite in that way. But if you'd like me have me file that separately, just as a single document for reference, that's of course fine.
That's true. Remind me.
So it's
where number 6 is in Mr. Turinini's testimony, attached to his testimony.
It's in Mr. Turinini's rebuttal, which is Washington Gas Exhibit 13. RET-R4.
Okay, I'm going to let you off the hook, Ms. Brennan.
Okay, thank you. That wasn't my only intent, but I will take it.
Sounds good.
Like I said, my goal is to not have you have too much paper, but to have all the paper that is necessary to complete the record.
You know, I feel like these hearings go really well, the actual hearing part, but the, circulating 10,000 emails and exhibits, that part's a little more difficult. So I thank the parties for working with me.
Of course.
Is there, and Mr. Dodge and Mr. Sheehan and Mr. O'Laughlin and Mr. Albert all shared documents and figured that whole thing out. That was a huge help to me. So I'd like to thank you all for that too. You did it even when I wasn't asking, and that's really great. It also makes our record, our public record, good. The video of this good. So I thank you all for your efforts with that. Is there anything else that we should take up this afternoon? I hope everyone has a wonderful weekend. Don't work too hard. Don't. I'm going snow tubing. I'm going to go play. So don't work too hard, okay? I hope everyone has a wonderful weekend. Thank you. We can go to the record.
You too, Your Honor. Thank you, Your Honor.
Bye, everyone.
Have a good night. Thank you.
Off the record.